Lord, item number 31 may kindly be listed on some other date. Lord.
Item number 31.
31, Lord.
You have informed the other side.
Lordship, can it be on the 4th of September, Lord?
September.
September 4th.
Okay. Mr. M. Das, Learning Council for the petitioner. And Mr. L. Talvir, Learning Council for the respondents. I have short listing of the case on 4th of September. List on the ground of difficulty on the part to do the case today. List the case accordingly on 4th of September.
Published.
May I please? I beg to mention item number 27 and 28.
Yes,
Lordship may not like to take up this.
okay. List the cases before any other events without me.
Publish.
May I please, Lordship?
In 27, name of Mr. R. Dhor, Learned Standing Counsel. Oh, Learned Government Advocate, be reflected in the cause list. Is to be reflected in the cause list.
May I please? I beg to mention item 37 and 38 supplementary mention with the consent of the other side.
37, 38.
Yes, ma'am. The consent of the other side, my lord. May come after 1 week, ma'am.
Yes, what is your prayer?
After one, I'm praying for adjournment for a week, my lord.
Okay. And you are in both the cases?
Yes,
Okay, Mr. B. Purokayastha, Learned Counsel, appealing for the petitioner, has paid for listing of the cases after a week. List the cases after a week on a date to fix by the office.
Please,
Your Lordship, I beg to mention a contempt matter, my lord, for listing the matter. I'm grateful, my lord.
May it please, your Lordship, with consent from the respondent, I beg to mention item number 29, Lordship.
29,
Yes, so it may be taken up in some other day. My senior has some difficulty today, Lordship.
Mr. G. Alam,
H. Rahman,
Learned
Lordship.
Counsel, H. Rahman,
Yes, sir.
the counsel for the petitioner has paid for an adjournment of the case. It is submitted that consent has been taken from the Learned Counsel for respondents.
Yes, I've taken consent, Lordship. I already
Make the
submitted the mentioned.
As sought for, list the case after a week on a date to fix by the office.
Interim order may be continued, Lordship.
Interim order, if any, shall continue. Listed.
May I please? My lord, on behalf of Learned Senior Counsel, Mr. M.Z. Damit, I beg to mention item 23. My lord, he is out of station. Kindly, my lord, on Thursday,
Not Thursday, next week.
Huh?
Next week.
Tuesday or Thursday, next week.
You have informed Mr. Choudhury.
Yes, my lord.
4th of September, Parina. Okay. Mr.
T. Ali.
An adjournment prayer is made by Mr. T. Ali, Learned Counsel, appealing for Mr. M.J. Ahmed, Learned Counsel for the respondent Code India Limited. Full stop. It is submitted that consent has been taken from the Learned Counsel for the petition to make the prayer as sought for and agreed to by the Learned Counsel for the parties. Is the case on 4th of September. 4th of September.
Published.
May I please, your Lordship? Also, with the consent of the other side, beg to mention item number 40 from the supply list, Lordship.
40.
40. Lordship, we have been engaged newly, Lordship. We need some time.
Okay, you have informed, you are the
Yes,
petitioner?
Lordship. I'm the petitioner, Lordship.
Petitioner.
Yes, Lordship.
Okay. You have informed the other side?
Yes, Lordship.
Okay, Mr.
A. Mena, Lordship.
A. Mena.
Lordship, can it be on 9 or 10 of September, Lordship?
Okay, we'll put it on 10. List on the prayer of Mr. A. Mena, Learned Counsel for the petitioner. Petitioners, list the case on so and so. It is submitted consent.
10th.
Lordship.
Supplementary list for motion. Item 34.
My lord, as per last order, this matter was directed to be listed for admission hearing,
Oh,
but listed on the column.
you will put it on admission the Tuesday?
Maybe, my lord, Bosor State Lordship can hear this matter. Matter is simple matter, 1 point.
Yes, yes.
He is only say Ajoy Kumar Choudhury case is applicable,
Fully
that is his
applicable.
case. Now let him say, my lord, whatever he say.
Okay, no, not, let it be on then Thursday in the admission column.
Yes, ma'am.
Admission.
Yes, no problem. Thursday,
Mr.
Thursday.
S.
That was
Probably
supplementary.
Learned Counsel for the petitioner.
Can it be on,
Mr.
my lord, next Tuesday, ma'am?
Next Tuesday.
On second.
Mr. T.C. Sutia, learned additional
Okay.
government advocate Assam for the state response have submitted that notice has already been issued in this case. And the case is to be listed in the admission column for admission hearing. List the case on next Tuesday. In the admission column.
All right.
Obliged, my lord.
For referral to mediation, item 1. I have got one mention, Lordship, for withdrawal tomorrow, Lordship.
Huh?
May I-
Withdrawal.
For withdrawal
Okay.
of license.
Yes, Mr. Prabhu. Can it be sent?
That is a lordship now. My lord, this case relates to payment of one of the terminal benefits of my.
It has been listed
now,
for
dividend, and
some
we are
mediation.
not asking anything extra, only whatever deductions, PPF and CPF, so my.
Yes,
client and
Mr.
respected friend
Dave,
has been
Mr.
for the
Dave.
last 3-4 occasions, he has
Mr.
been
Dave.
ensuring will make the payment, but categorically simply.
Mr.
My lord, we have nothing. to-
Mr.
and there is
Dave.
No scope of mediation, my lord. No bargaining, nothing of the sort. We are not asking for an interest. Only whatever deduction is that, and my respected learned friend is assuring, yes, it will be paid and it will be paid. And before 2 months also, another letter has been originated from the executive engineer at Silchar, where from my client has been retired. So my humble submission is there is no scope of any mediation and nothing. We are not asking.
Okay,
for
then
any-
we'll list it for hearing then.
Lordship,
If you are not interested in mediation,
Lordship,
I think mediation is an important tool nowadays.
Lordship.
It can be sorted out easily.
But he's bedridden, my lord. He's bedridden. He can't move. He's an old.
That
age.
is why it is shortlisted for mediation so that it can be sorted out.
But he cannot remain present.
No,
My-
online it can be done.
He's in a village, so online all these facilities, I confused whether.
Yes,
can
online
be
you can make an effort. If it is failed, then definitely we'll take up.
Yes.
I think that, at least we should make an effort.
Lordship, Lordship.
Okay, my.
We'll observe that it is bedridden, you are bedridden and online also. Yeah, heard Mr. G.R. Deb,
Yeah, my lord.
learned counsel for the petitioner.
I am for 1, 2, 3, 4, and 5, Lordship.
And Upaidhya. Learned Standing Council Irrigation Department. For the respondent number 1 to 5. Mr. R.K. Talukdar, Learned Standing Council. Accountant General for the respondent number 7. Any finance? Yes, can it be recorded, Mr. Dhar? Whose name? K.R. Borbuzai, Learned Standing Council for Finance Department for the respondent number 6. Full stop. The subject matter of this writ petition is non-payment of ZPF dues. ZPF due.
GPF and CPF, some combined.
Other ZPF,
Only provident fund consisting of GPF for some period, there was deduction of GPF and after that it was converted to.
but
GPF.
substantially it is GPF and other pensionary benefits,
Other benefits he has received.
Receive, Lordship.
ZPF dues. Full stop. The case has been listed. Has been identified for inclusion for referral to the special mediation drive, that's mediation for the nation. Post of having regard to the issues involved, this code is of the view that there is an element of settlement. Post of. The first date of mediation is therefore fixed on 4th of September. 4th of September. The standard operating procedure permits the willing parties to appear in the mediation,
Fourth, my lord.
okay. Fifth,
Fifth, oh.
okay,
applied
fifth.
my-
The standard operating procedure permits the willing parties to appear in a mediation, either in offline mode within bracket physical mode, or online mode, or in hybrid mode. After Deepak, coordinator of the mediation shall ensure, no, nalage, service nalage. For the purpose of further reference, the party shall contact the coordinator, nodal officer, mediation center, so and so. This is the case. Immediately after receipt of the mediation report. Fifth of September,
Fifth, oh,
online you can appear.
applied my.
Item 2.
Yes, Mr. Patgiri.
No.
Patgiri, here Patgiri, petitioner. Yes, Doctor, Standing Council, Panchayat and Rural Development Department for the response number 1, 3, 5, 6. R. Taludar, you were there?
Yes, Lord.
Okay. Which one?
Newly implemented, madam. Newly implemented.
Newly implemented? Okay, newly implemented. Response number 8, Accountant General. Mr. D. Bora, State Council, for the response number 2 and 4. Compassionate
Family pension.
family bench, subject matter. Element of settlement. 5th of September.
Obliging. Item 3.
Claim is what?
And what is
Family pension
family
as a divorced daughter.
divorce daughter.
Okay.
And he is the
Council is not available.
last time also council was absent, my lord.
Okay, the counsel for the petitioner is found absent today on call. Ms. Gayon, A. Gayon, standing on counsel for all the respondents.
Yes, my lord.
Is present in list the case. In view of absence of the learning counsel for the petition, list the case again on next Monday. Again on.
Item 4.
Lordship, the
Areas of minimum scale of pay.
His lordship.
Yes, Miss,
The petitioner has received her entitlement.
received,
Yes.
so not required. Okay, Miss
And DECA.
and Decca, Learned Counsel for the petitioner has submitted that during the pendency of the writ petition, the petitioner has received her dues, as claimed in this writ petition. So the petitioner has is therefore not interested to pursue the writ petition. Miss,
Hearing for respond number 1,
Miss
U Sharma.
U Sharma, and you are for?
PCA for respondent number 4, 5, 6, and 7.
Okay. Government Council. Miss U Sharma, Learned Council appearing for?
Respondent 1,
You are finance standing council.
government. State council.
For a respond number?
Respond number 1.
Okay. Learned State Council for the respond number 1. Miss
PCA for
P-
respondent number
PN.
yes 4, 5, 6, and 7.
4, 5, 6.
And C Hills.
Okay. You are standing council.
And C Hills.
Standing council. Standing council for the respond number 4, 5, 6, and 7. Are present in view of the above submission made by Miss. So it's all learning council for the DECA and council for the petitioner. The petition is dismissed as not faced.
Much obliged.
Item 5. In this matter, the claim was for pension. Then the affidavit, my lord, filed by the, my lord, pension department, they have denied the claim. So, my lord, perhaps, my lord, it will not
Make
be.
an effort, then, if it fails on the first day, then again it will be
Right.
listed.
Right.
At least you make an effort. Sometimes difficult issues are sorted out.
Right.
H. Gupta, petitioner. Miss
U Sharma.
U. Sharma, London State Council for the respondent number 1, 2,
4, 5, 6 and 8, Lordship.
4, 5, 6, and 8.
A Buru on behalf of Mr. C Buru for respondent number 7.
Okay, A. Borua. Respondent number for the A. Borua, London Council representing Mr. C. Borua, London Standing Council. Accountant General for the respondent of 7 are present. Full stop. R. Pujari. London Standing Council. Finance Department for the respondent number 3 are present. Full stop. This is release of family pension.
Family pension, my lord.
The subject matter of this petition is release of family pension in favor of the petitioner. Element of settlement. 5(9), online, offline, hybrid. Huh? Report immediately after.
Item 6.
What is the subject?
Family pension matter, Lordship.
Proportionate.
Lordship,
Proportionate.
proposal of family pension.
Proportionate family pension.
Family pension, Lordship.
Mr. Borua,
RL
Chetia,
Tutia,
RL Chetia,
Chetia.
petitioner.
Respondent is admitted.
So it can be done then. R. Chetia, RL Chetia. U. Sharma. Okay, State Council, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. R. Talukdar.
For 12, my lord.
12. Accountant General. R. Pujari, 13 and 14. Proportionate family pension. 5(9). First date.
Item 7.
Retirement benefit.
Lordship, matter may kindly be adjourned for the day, your Lord.
No, we are putting it in mediation. Miss
R.
R.
Datta.
Dotto. Petitioner. S. Dotto.
R. Datta.
No, you are R. Dotto.
Yes.
He is S. Dotto. Standing Council, Concern and Rural Development Department for the respondent number 1, 2.
My lord, 1, 2, then my lord, 7.
7. Nibora.
TN5.
D. Bora, State Council. TN 5. Mr. B. Sharma,
4.
Accountant General for the respondent number 4. 7. Release of retirement benefit. 5(9).
Yes, I say not. Yes, also necessary.
Oh, R. Rosary, Finance Department, respondent number 6.
Item number 8.
My lordship. Lordship, actually, here a particular period of service of the petitioner, which.
Regularization of gap period.
Yes, ma'am.
Lordship, that's
Let us try. Let us try. Mr.
NZ Chaudhary.
N.J. Chaudhary, petitioner. Miss M.D. Bora,
For 1 and 2, my lord.
Standing Council, Transport
Trans-
Department, 1, 2,
1 and 2.
and R. Pujari, 3. Regularization of gap period. 8, 9,
Lords. Lordship, can it be after 11, my lord?
11,
After 11, 12,
okay, 12.
my lord. April
Or before, can it be done before 5th of September?
5th of September.
5th of September.
Item 9,
Regularization of service,
No. Family pension.
Hmm?
Family pension.
family pension, okay, as does. Petitioner. Mr. Dhar, you appear for
PWD, my lord.
Standing Council, PWD. For the respondent number 1, 2, 3.
My lord.
Mr.
Number 4 on behalf of SKM.
Mr.
SKM.
AKMD, Land Council, representing Mr. SKMD, Land Standing Council, Accountant General. For the respondent number 4. Family pension. 5/9? 5/9.
item number 10,
What, regular scale of pay?
My lord, this is little difficult, but I think we have to file affidavit here. Because he is seeking regular scale of pay. These are issues whether, my lord, can be determined in
If it fails, then we will proceed. Here, Pargiri petitioner. Ardhar,
mediation.
PWD. 1,
My lord,
5,
1,
6,
7,
7. R. Bopuzari, Finance. 2, and Treasury Officer, 8. Treasury Officer also, 2 and 8. Miss
my lord.
M. Bhattacharya, State Council for respondent number 3. B. Chakraborty, Central Government Council for the respondent number 4. Okay. This is for what? Subject matter is?
Family pension, my lord.
Family pension. Okay, family pension. Or minimum scale.
No, my lord.
Family
Already
pension.
regularized, my lord.
Okay, family pension. 5/9. 5/9.
Oblige.
Pardhat matter for admission, item 35,
3টা বাজে না? 3টা বাজে। Mr. Kaushik at 3 o'clock?
At 3 o'clock.
Both part heard.
Well, I think there is one matter fixed at 3 also.
Same, we'll pick up both that.
Well,
We'll release that. You show me that, you correct that one. You showed accused is covered under one section, 160.
my lord.
Accused is covered under one section, section 60, 160.
for admission, items 11 and 12.
They're too good. What is this IA? IA or what are to be taken up?
Look, actually, I is filed by,
Reading is complete.
reading
Yes,
is
my lord.
completed.
Then what is the need of IA?
My lord,
Let us have the,
my lord.
if it is required, we will take up the IA, but if it is not possible, if reading is complete, let us.
Flush.
try. Yes, what is your case?
Yes, my lord. My lord, my respectful submission, my lord, that before my lord, I have challenged the memorandum of charges, my lord.
Memorandum of
Of
charge.
charges, yes, my lord. And at the very outset, I draw my lord's attention to my lord's order dated 8th of January in item number 12, my lord.
8,000, item number 12.
Yes, my lord.
Item number 12.
Ram Narayan Chaudhary.
WBC number?
19th.
19, okay. Date, order date?
8th of January, my lord.
Memorandum of charges. Issued to him to it, directing the petitioner to submit statement of defense. So for us, 2011, 2024. Passed in WBC number 4861. What is 4861? Randhir Kumar. You represent these petitioners also?
Yes, both the petition.
Okay. Is it ordered it? 2811. 2811. To represent approach this court, agreed by after violation. Has paid for some time to obtain each right. Appears right. Subject to so and so. Based on the impugned. No reason is assigned for interim order.
Yes,
But
my lord.
anyway, so we have to understand it.
Yes, my lord. If my lord permits, I beg to submit a convenience note for my lord's perusal.
Let us have a look at the memorandum of charges.
Yes, my lord.
Some convenience note I have already seen somewhere.
My lord, I beg to submit
I
that.
to go to tell you. I to tell you. Yes, I have seen one convenience note here. I have already seen one convenience note. Yes.
My lord, page number 31, my lord.
Of which petition? RN Chaudhary.
Yes, first one, my lord, 11.
RN Chaudhary.
Randhir Kumar, my lord.
Randhir Kumar.
Yes, my lord.
(31). Statement of article of faith. Yes.
My lord, before I submit respectfully, I state to my lord that there is a common proceedings of 13 personnel. Out of the 13 personnel, my lord, 3 personnel came to this honorable court and 2 personnel went to Itanagar bench on the ground of jurisdiction. In both the cases, there is a stay. Rather, Itanagar bench on 4th of April of 25, my lord, Honorable Justice K.R. Surana gave passed and very exhaustive order. If my lord permits, then I can, because it is all reference to the entire scenario of the Yes, my lord.
Yes, Mr. R.K. Devchuri.
Lordship, I am not privy to that order. But in my case, that is item number 12, there is no interim stay. And so far as Lordship, the challenge to a charge sheet is concerned,
No, but question is about,
that Lordship, that order passed by Honorable Justice Surana, Lordship, I am not privy to that. In fact, he has also not served to me. Otherwise, Lordship can do one thing. If all the cases are taken up together, maybe that will be
because
easier.
there will be otherwise
Otherwise, there will be,
conflict of,
Yes, my lord.
There-
That is why that
there,
case is
there
different.
may be.
what
Lordship,
kind of order? Let us have a
Yes,
look.
my lord. If my lord permits, I'll.
Please serve it to Mr. Devchuri because then question of jurisdiction also comes. Where is the jurisdiction then? If some repetitions are filed for against the same memorandum of charge in Arunachal and some are filed here,
Yes, Lordship,
then question of jurisdiction comes.
In fact, my lord, in item number 11, petition number 2, he posted in outside Assam, my lord. Nowhere connected here.
No,
The
that is
jurisdictional point is
posted
there.
out. No,
No, no.
posted. That is not the issue,
no.
Mr.
here
Swami.
some,
He may be posted outside now.
No,
But
never.
if
He was never
please,
posted here.
what is the cause?
because,
Cause is some employment of laborers, right?
yes,
So it was in Arunachal Pradesh or Assam?
Yes.
Where?
it was in Arunachal.
Let us have a look at the page 31.
My lord,
What
simply-
is Phokar and Sapi?
My lord, that is the unit, my lord.
Where it was done?
My lord, basically, this,
Where it was done?
that was
Which
in,
place?
that was in Kargil during COVID time, my lord.
No, which place? Which state?
That is in Kargil, my lord.
Huh?
Kargil, Jammu and Kashmir.
Jammu and Kashmir.
That is, my lord, what is happening, my lord? There we
No,
have
no.
a,
First, let us understand this Phokar and Sapi.
yes, my
This
lord.
place was where?
Fokar and Sapi.
Where?
That is in that is in my lord, in Kargil. We have a project.
Right. Then what these repetitions are doing here?
My lord, they are posted here, my lord.
That cannot be.
Yes,
Is it
my lord.
that posting will give the jurisdiction?
My lord, yes, my lord. That is the ADGBR office in Lankeshwar, my lord.
No,
They
longest.
also-
Where is the cause of action?
My lord, cause of action have been, my lord.
Let me see it, this order
Simply speaking, my lord, first,
at the outset.
Well done.
See the last line, 16, paragraph 16. Paragraph 16 of the order. Yes, please.
It's not given.
Please give him the order, copy of this order.
Itanagar bench order.
Ah.
Yes, yes.
Otherwise, how can he know? Okay,
Yes.
okay, fine. Yes, Mr. Devchuri, last paragraph. Two kinds of interim prayer. First, interim prayer was not allowed, giving certain directions. Second interim prayer regarding stay, because of this stay, that was stayed. And last paragraph, paragraph 16.
Those are to be.
Because apprehending, conflicting,
Yes, there might be conflict. There might be conflict.
so that
That has to be tagged together.
registry has to put up a note then in this case,
That will be on
in view of
the,
that order.
that will be on the administrative side of it.
No, registry will put up a note. Because all the cases should be
Together.
taken up together, otherwise difficult. How many repetition? One there.
Two, my lord.
Aman Kumar. Similar order was passed in the other one. Or this is a common order.
This is common order, my lord,
But
in both the petition.
but here only one is mentioned. Only one is mentioned here. That is,
My lord, inside it is there that the second petitioner should represent for not considering his name in the DPC, my lord. I apologize, my lord.
how many petitioners there? Okay, two petitioners.
Two petition.
Okay, single writ petition.
Yes, my lord.
Okay. Then, Resti may
Lordship.
give the report, give a report. We'll quote this paragraph.
Yes.
Heard Mr. S. Das, learned counsel for the petitioners in both the writ petitions. Mr. Goswami, you are for?
He is in the first one, Lordship, item
Okay.
11.
Mr. U. K. Goswami, learned central government counsel for the respondents in
WPC one.
Will you say 461?
4861, 2024. And Mr. R. K. Devchuri, learned Deputy Solicitor General of India for the respondents
Response.
in WPC number
19.
19/2015. Full stop. Mr. Das, learned counsel for the petitioners, submitted that another writ petition,
A number to likhi lo, sir.
WPC number 482/2024 has been instituted by two other petitioners assailing the same memorandum of charges dated 2/8/2024. And the said writ petition is pending before, before the Itanagar bench. And the state writ petition is pending as on date. First off, by placing, Mr. Das has placed a copy of an order dated 4/4/2025, passed in WBC number 482/2024. Poster. Paragraph 16 of the order dated 4/4/2025 reads as under paragraph 16 to Likibo. The Korean bench has passed the above order in order to obviate conflicting views. First off, the registry to place a report on the aspect regarding taking up the other writ petition from a WBC number 482/2024 with the present two writ petitions. List the case on and list the cases on 8th of September for a report.
My lord, 9th of September will be convenient, my lord. In the meantime, records can be called for, my lord.
That is only for the report. We don't know. It is the Honorable Chief Justice who will do
9th of September.
on his administrative side. Let us have a report.
Interim, what
If the interim order wherever passed shall continue.
Deeply
Till the
obliged, my
next suggesting, because he will pass an order in the administrative side and court will receive a prize. We are only for a report, then we'll fix a date. If he
Deeply-
declines to get it, he may say that this repetition be sent. Then it may be otherwise also.
Deeply obliged, my lord.
Items 13 to 22.
No, এই প্রথম সিরিয়ালি যাব প্রথম কেস
My lord, there are quite a few petitions.
Yes, looks like.
The basic issue involved in this case, my lord, the petitioner Soilendra Kumar Deuri, he was initially a joint secretary health in the government of Assam. And at that point of time, the Tezpur Mental Hospital was under the state government's in control.
He has preferred how many petitions?
Actually, basically, Soilendra Kumar Deuri's petition is there. Then, my lord,
Soilendra Kumar
three other
Deuri, right?
petitions are there.
Soilendra Kumar Deuri,
Yes.
not Medi.
No.
1, 2.
My lord, the first in point of time.
And what
that-
is Dhrubajyoti Setia?
I think my learned friend represent. Yes.
He has interconnection.
Not interconnected, my lord.
Huh?
Segregate matter.
Let us be, because it will be difficult for the court also if it is not. So Soilendra Kumar Deuri
In
is,
fact, my lord, a decision in WPC 3769 of 24 to a large extent will, my lord, solve the problem in other cases.
37,
Yes.
37,
64.
376,
17.
17.
70.
Earlier in point of time, Niki Hitwe.
It will solve.
So what are the grievances, grievances
I'm
of
coming
Mr. Just 1 or 2 lines?
Yes. My grievance is, my lord, since I am a faculty member, both under the state government rules as well as under central government rules, I am entitled to serve up to 70
As a
faculty. And
Okay.
also as a, my lord, director of the institute.
Okay. And what are the grievances of Dhrubajyoti Setia?
Yeah. One case is suspend for stay order. And next, disciplinary proceeding initiated and one case. Other case, other section 40. Yes. We got stay order there. Thereafter, my lord, in one case, they have already terminated me. My lord, premature retirement given to me, and that was challenged. And during a pendency of that test, and the government has submitted one document that person, director who has done retirement to me, that was not allowed.
Okay, are you an aspirant for faculty member or this continuation? Are you agreeing in any manner with the continuation
My lord,
of,
what-
with a claim for continuation of Dr. Deuri?
In one case, was implemented.
Okay, that is different, but are you an aspirant or are you challenging his
Yes.
claim for continuation as faculty member or something?
No. It is another issue.
So you are basically, you may be a respondent in one of the writ petition, but so far your writ petitions are concerned, may not be directly connected with the relief sought for by
No,
Mr.
sir, there
Deuri?
is only one connection I'll indicate. His first order was signed by me. Subsequently, the order which I passed has been issued by my successor in the office. So that way, my lord, his termination stands. That is under chat.
But not regarding,
That way, these two cases are not interconnected.
There is no interlinking. Only ground is that lawsuit that Soilendra Kumar Deuri has issued the first termination order.
that is a different issue.
Different issue. Go ahead.
That he will contest differently as a respondent perhaps,
Yes.
Dr. Deuri.
Yes.
Right. That is one. Then there is another one, Dhrubajyoti Setia.
Yes.
He is the Dhrubajyoti Setia.
Okay, then who is Konkon Pathak? Do you have any connection with?
20 years. I am saying that as the senior most faculty member, I should be appointed as the officiating director.
Okay.
There, and in item number 22, your lordship, what has happened? That the private respondent who is holding the post, during the pendency of the first is publication. That was stated. Item number 22, sitting under FR 56, your lordship, for compulsory retirement or initiation. So that then I am automatically out of the race. So that was challenged and that has also been.
So, this, Dhruvajyoti CTS can be taken up separately.
Of course.
Of course.
And what about Concon?
Perhaps they will have some relevance. Those petitions of Dr. Konkan Pathak will perhaps be connected to these because first prayer in the first petition is that I should be appointed as the as the senior most factor. And the second petition is directly an offshoot of the first petition because I was moved because of my candidature or because I was attempting to occupy that.
Well, that is why I'm saying a decision in 3769, if your lordship upholds that I am liable, I'm eligible to continue up to 70 years, all these things will my lord, fall flat.
There will be some relevance there, some interconnection is there.
Item 20.
So lordship may take the segregate the Dhruvajyoti CTS matter, otherwise all matter.
Dhruvajyoti, then Dhruvajyoti should be segregated perhaps. Otherwise, there will be many confusion.
Issue is different.
Dhruvajyoti is item number 14, 15, 16, then 19, and 21. Okay, and Soilendra Kumar Deuri, item number 13, 17, 18. Aru Konkan Pathak, 20 Aru 22, huh? So, egita Dhruvajyoti CTS separate koi thok. Yes. Dhruvajyoti CTS cases are detect. And we proceed with then Soilendra Kumar Deuri's case.
Yes.
And if required, Konkan Pathak.
22, item 22 is not relevant, my lord, because the authority issued a letter asking for submitting some documents to review the performance under FR 56J. It is the normal process of the government. And this letter was issued, administrative letter, my lord, issued.
Yes, Mr. Pathak.
I categorical allegation at number 20 because I have got my candidate for the private respondent who is occupying that post now illegally, according to is seeking to initiate this process. Clarify the matter to house.
Are you a party respondent in his petitions?
No, I am
It
the
is
senior,
normal
otherwise,
practice,
I
my
told
lord.
him I am the senior most factor.
Only to determine whether his service is necessary for the institute or not. It is to be decided. It is the normal process, my lord.
Let us have first Soilendra Kumar Deuri's cases.
Yes, my lord. 3769.
Etu more rahibo, etu bishat last order detect kori dibo rahibo. Which one you want to?
Well, item number 17.
Also, I pay for any day losses after segregating my lord, fix any day loss. Today we both are discussed regarding segregation part.
No, we can start, my lord. In any case, it will take some time.
Any
can
day,
start-
my lord, it is very
start,
trouble.
my lord.
It is very trouble to go through all these things, all the cases, my lord.
By yesterday's discussion, both of us lordship
My lord,
for segregation.
To
part.
do this case, I
Otherwise,
have
am
taken
not-
adjournment in 4 cases today.
Otherwise, you can.
They are-
Keep the Pathak.
Oh, no, I'll not give Pathak.
No, what I'm saying is.
This, because
any
I
case-
have already
in any
Pathak,
case,
I have to
matter-
clear those Pathak.
What I respectfully submit, my lord, until 1 o'clock, I can conclude perhaps. Then they can give their reply on another. In any case, it will take some time. my lord.
Because I have to clear all the Pathaks, because I was in a different mess.
Okay.
Now, many Pathak matters I have fixed at 2 or something, something. And those are to be cleared this week, so that I want to be free. We can start with a clean slate any day. We can start at you choose your date. We can start at, say, Tuesday. If you want 2 p.m., we can start at 2 p.m.
Next Tuesday, Mila.
Huh? It is up to you, or we can put it in the list. You make a mention.
Yes.
As per your convenience.
Yes.
All of you come, we'll start.
Milord, let us keep it for Tuesday in case of any problem. We'll pray for some accommodation.
Make a mention that we'll start at 2 o'clock. We'll start at 2 o'clock, we'll do it. And
Milord, I'm sorry, Mila, I'm told to second, I'm not there, let it be fourth, Milord.
Okay.
Fourth.
Fourth. Okay. We'll segregate the cases to for Dr. Dhubajyoti Setia.
Milord,
When do you want?
Milord, the interim orders will have to be extended.
Or wherever it is there. 9. Okay. Mr. Tenchuri, Senior Counsel, estate by Miss Kakoti, R. Kakoti, learned counsel for the petitioner in 13, 17, 18. Mr. K.K. Fukan, learned counsel for the petitioner 14, 15, 16, 19. And Mr. K.P. Pathak, learned counsel for the petitioner in item 20 and 22. Hello, huh? Tinjan Melag, huh? And Mr. K. Gogoi, learned State Council, Central Government Council. R. Dhar, learned State Council, and Mr. A.K. Dr. learned Central Government Council. For the respondents are present.
For the institute, my lord.
Treasures.
SCLGBR.
For the, okay.
Look up your Gopinath,
Central
LGBRI.
Council, LGBRIMH are present. First of it is submitted that and by the Learning Council for the parties that the issues involved in item 14, 15, 16, 19 and 21 can be segregated from the other batch of repetitions. First of list the repetitions, huh? Item 13, 17, 18, 20, and 21 on Tuesday.
22.
Or 22, sorry, 21, no, 22. Konkon Pathak, Aru, Dr. Dhruv Shailendra Kumar Deuri. Naam kira mon rakhibo. Ekita Tuesday.
Thursday.
Thursday. Thursday. Which is Thursday and Mr. Fukan. Edu. Heri keta. Dhubajyoti Setia keta? No.
9th.
9th.
Interim orders will continue.
The interim orders, wherever passed, shall continue in the meantime.
April.
Okay. If next year, sir. Admission give us.
Supplementary list, item 36.
Tinta naam ase Musumrari. Dutar Thursday. Baki etar. Okay. Yes, sir.
May I please your lordships. My lord, this petitioner before your lordships,
Where is Mr. Pathak, KP Pathak, KPDCL?
his presence is required lordship.
Huh?
Last time also he was absent because of that.
He was there just now. Made by so and so is not available before I go. The prayer for adjournment is made. Yes, sir.
Lordships, on 1/1/2014 lordships, this petitioner got retirement lordships. And
1/1/2014. 1/1/2014, retired.
retired lordships.
Ah,
And lordships on 19/8/2014,
19?
2014, an amount of rupees 1,58,750,
1,58,760.
760 lordships, deducted from his retirement gratuity lordships. That is out of 7 lakhs lordships.
From
lordships-
retirement gratuity.
Lordship, this petitioner filed a writ petition in 2023, lordships.
Ah,
He approached before this honorable court for 10 years, lordships.
right then.
Lordships, this petitioner, prior to retirement in 2010 itself, lordships, he was suffering from various diseases, lordship. And accordingly, lordships, he was under medical treatment. And because of medical treatment, every now and then, lordships, he was going to the Chennai for medical treatment. Those medical papers I have annexed. And also, lordships, regarding the limitation part, lordships, I have explained in my writ petition in paragraph 6, 12, and 16, lordships. Now, this petitioner has approached before this honorable court that amount which is deducted illegally, that is to be refunded back with interest, lordships. With
Interest after 10 years, no.
lordships, and regarding
If it is allowed, suppose, then there is one claim is late. Only 3 years, somewhat like that.
lordships,
Although-
Allow my learned friend to finish.
We are not jumping at any decision. I said that if it is allowed,
Yes.
then interest is only for 3 years.
The date of the recovery order would be critical in this.
We'll look into it. 1 minute, just let me have a look.
lordship.
Okay, where is the recovery order? You retired from what post?
Lordship, sub-engineer, lordships,
Sub-engineer.
engineer, grade 2.
Let us flip through the documents first.
Lordship, page 19, lordships.
Page 19. Retirement gratuity and family business sanction. So you are having pension.
Pension I am getting.
With effect from 2/4 prior to the date of. Your date of retirement is 1/1/2014.
Lordships,
Date of retirement 1/1/2014 or 31st December?
31st December, lordships.
Date of retirement perhaps 31st December.
31st December,
Ah,
pensionable date 1/1/2014.
pensionable date. You are eligible for pension since 1/1/2004.
Lordships.
Why in this page 19, date is pension is from 2/1/2024? There are commuted pension, commuted value, retirement benefit. Subject to outstanding liabilities being excess pay. Okay, this is page 19 is your office order whereby pension, commuted value of pension, retirement gratuity, etc. Been allowed.
Lordships.
Then next, what is the next page?
Lordships, that is the
Member
operative
Secretary.
payment of
Authority for payment of debt. Maybe dispersed to. Okay, this 5,41,240 is after
Lordships.
deduction of 1,58,000.
Lordships.
Amount of so and so outstanding liability. And yes, please tell me then. Next.
Lordships is regarding checking of service book lordships. Whatever is supplied to me lordships, those are annexed along with the documents lord.
Admittedly excess pay. Admittedly excess pay.
Lordship illegally deducted lordships.
No, deduction is admittedly excess
Lordships.
pay.
Lordship.
You are not contesting that part, that excess pay was made. You are relying on Rafiq Masih principle.
Lordships.
Medical report. Then next 10 years you are what? Suffering from illness.
Lordships. This
That is your case.
Lordships. Page 13 words. I have annexed the medical papers. And since 2010 lordships, as on now, the medical treatment and lordships, at present lordships, the petitioner requires helping hand for feeding and natural calls also.
Then what you are relying?
Lordship,
Coordinate bench.
lordships, two judgment passed by this honorable court, I have annexed page 52 lordships. Tikendrajit Medhi.
Those are in 2015.
Lordships.
Now he is raising an issue that after 10 years, they are trying to distinguish your case that two petitioners, maybe. Let us assume for a moment that overdrawal was there. The recovery also could have been made as per principle of Rafiq Masih. That is one. Second part I will come. But you are late by 10 years.
Lordships.
So you are not vigilant.
Lordships.
You slept on your right. You were in deep slumber. One fine day, you woke up, started demanding. Now the question is, recovery, this recovery part, whether it is a continuing wrong or not. That is the issue.
Lords.
That whether the recovery is still being made presently, then it will become a continuing wrong. Or if it was only deducted in 2014 and that is the end, because the recovery was from the-
Question is one time wrong or continuing wrong?
It is only at that time deducted.
Mr. Sharma, I have not said for the servicemen for last 4 years. So I don't know Rafiq Masih and all. I have forgotten everything. Tell me, it is a continuing. Mr. Pathak,
Lordship,
that submission may not be countenance that Rafiq Masih is prospective.
Because your lordship, this
because
is permitted.
if you give me 24 hours, I can place at least 10 judgments prior to it.
No, that principle, because the petitioner
Rafiq
is,
Masih is reiteration of earlier principles.
it is.
So Rafiq Masih is not the
It is not
first one in the
first,
line.
definitely.
It is one of the decisions in a line.
In fact,
There
the
are
judge-
prior decisions.
The judgment in Rafiq Masih itself contains references to the
Huh.
earlier judgments, your lordship.
So that submission which has been recorded may not be subject to you.
No, because I had made those submissions because it was said to be covered by the coordinate bench
Right.
judgments. That is, I said that those were not covered.
That is just a move, you place this, that this is a continuing wrong and the matter.
Lordships, this
Continuing wrong. I have understood your case, 1,58,000 deducted in 2014. You retired in 31st December 2013. Started getting pension from 1/1/2024. Then it was clearly indicated in the pension payment order that 1,54,000 has been deducted from your gratuity because of excess drawal, right? So you slept for 10 years. Now you have, after 9 years, you have approached this court. So this deduction is continuing wrong, that every day the wrong has continued.
Lordships, this regarding my delay, Lordships, filing of writ petition.
No, question is not that. The question is about delay.
Lordship, this,
Question is, if it is, because whatever is there was excess draw.
No.
Right. Fact of the matter is excess drawal.
it's their calculation, Lordship, not my calculation, Lordship.
Yes, not it.
Prior to that, no notice, no hearing was afforded to me, Lordship. And also, Lordships, this Learned Counsel for the respondent insisting on prospective order and retrospective order. Lordships, all orders, all judgment and orders of the Honorable Court are retrospective, Lordship.
That is interpretation of statutes. Or interpretation of statutes, perhaps. If I have, with my limited knowledge,
Principle is it apart from Rafiq Masih, because that is a continuation of previous pronouncements.
principle is always there.
Prospective, unless specifically made retrospective.
But other than Rafiq Masih, there are other decisions
Yes,
already.
yes. That is why I am not insisting on that.
So apart from Rafiq Masih, there are other decisions earlier. So according to that also, recovery of excess thing, law principle has been laid down. Question is about delay
Delay in latches.
and latches.
Lordship, this regarding delay, Lordship.
Right,
Last
please.
time I have placed one decision, Lordship.
Yes, yes, please.
Lordships.
Conisco.
Lordships, that is retrospective, Lordship, honest.
This is Conisk.
Lordship, one more.
That
area,
is
Lordship.
Justice
This is
Sudhanshu
regarding-
Dhulia, retrospective. Judgment of the court. Conisk.
Lord, no, that is retrospective, Lordships.
Oh.
Now regarding.
Please go to the paragraph. Which paragraph?
Lordships, paragraph, Lordships. Page 3, Lordships. Page 3, bottom, Lordship. The-
This judgment you have already given. Yes, what is there?
Lordship,
in receive high,
Lordships, in this Lordships, this petitioner approached before the Honorable Court in one petitioner approached in 7 years and another 16 years Lordships. In 16 years, that petition was entertained Lordships, and though the petitioner
one
They-
minute,
Lordships, that is
1 minute, 1 minute. Itu. 1990. এইটো রিলাই করে পিছু দিয়া পিছন দিন ফিক্স করে Yes, Mr. Pathak, here that no third party creation of right or
Yes, sir.
something like
Yes,
promotion or interest, seniority, something like this are not issues here. It is purely between APDCL and the petitioner. It is a case of pension.
Lordship.
Yes, delay has occurred, but this otherwise, had it been on the last date, he earned a salary. And thereafter, after long years of service, he expected it. But at an earlier point of time, some overdrawal was excess, wrong calculation, not a fault on his part,
Yes,
as
sir.
per the profit principle.
Yes, sir.
Then this concept that one is continuing wrongs, the other is recurring or successive wrongs. And it says belated service related claim can be rejected on delay and laches or limitation. But there is an exception in cases relating to a continuing wrong.
Continuing.
Then there is an exception to exception.
Lordship.
Right. If it is third party rights are created, he is claiming seniority, something like all this, that's some third already a settled position. And after long back, it is claimed, then it should be rejected. But so far as one-to-one related to pension related or something like that, then this can be treated as an exception to exception.
There is a constitutional bench judgment, Your Lordship.
Yes,
I do
this
not
is,
know if
this
it
is
is
Tarsem
discussed.
Singh. That is what I.
Tarsem Singh and
Ah.
in Bhailal Bhai also, because at the end of the day, Your Lordship, this is a claim for recovery of money. So in Bhailal Bhai, what the constitutional bench held, Your Lordship, is that because his right is crystallized, there is no problem regarding it. Is the issue is regarding the remedy. He had the right which was there in 2014. In Bhailal Bhai, what the apex court held, Your Lordship, is that in prayers such as this, though it is a service matter, it is in essence a recovery of monies due. There, the period prescribed under the Limitation Act will be applicable. Paragraph number 21, Your Lordship. The learned judges have appeared to have failed to notice that the delay in these petitions was more.
1 minute. There are 21.
Para 21.
Delay in this petition was more than the delay.
Delay in the petition made in so and so, out of which civil appeal number 362 of 62 has arisen. On behalf of the respondent petitioners in these appeals, Mr. So and so has argued that the delay in these cases even is not such as to justify the refusal of the order for refund. We argue that assuming the remedy of recovery by action in a civil court stood barred on the date these applications were made, that would be no reason to refuse relief under Article 226 of the Constitution. Learned counsel is right in his submission that the provisions of the Limitation Act do not apply to the granting of relief under Article 226. It appears to us, however, that the maximum period fixed by the legislature as the time within which the relief by a suit in a civil court must be brought may ordinarily be taken to be a reasonable standard by which delay in seeking remedy under Article 226 can be measured. The court may consider the delay unreasonable even if it is less than the period of limitation prescribed for a civil action for the remedy, but where the delay is more than this period, it will almost always be proper for the court to hold that it is unreasonable. The period of limitation prescribed for recovery of money paid by mistake under the Limitation Act is 3 years from the date when the mistake is known. If the mistake was known in these cases on or shortly after January 17, 1956, the delay in making these applications should be considered unreasonable. In this case, Your Lordship, if Your
What is
Lordship,
a claim?
yes, if Your Lordship has the prayer,
No, in this.
oh,
particular-
in this petition, yes, Your Lordship. Lordship will find that in the first paragraph. These appeals by the state of Madhya Pradesh are against the orders made by the High Court of Madhya
Tobacco
Pradesh.
dealers.
Lordship,
Tobacco dealers.
tobacco dealers, but for the prayer was for refund of monies illegally taxed. I'm otherwise this amount, your lordship, is small, but the legal principle, I'm just on the legal issue, your
Hmm.
lordship. And there is another judgment, your lordship, though it was, that was in the nature of section 472 of the CRPC regarding continuing offense. There, the Supreme Court went to the extent of saying that even for enforcement of fundamental rights, if there is a delay, your lordship, then it will be fatal.
But here also, after this thing, concept of continuing wrong and recurring wrong,
Lordship.
this MR, Gupta, then Tarsim Singh,
Lordship.
then this judgment
Lordship.
said, in Tarsim Singh, it was 16 years.
16 years.
16.
That it says, but there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affected several others also, and if the reopening of the issue to affect the settled rights of the third parties, then the claim will not be entertained. For example, if the issue related to payment of refixation of pay or pension, relief may be granted in spite of delay as it does not affect the rights of third parties.
Okay.
But if the claim involved issues relating to seniority or promotion affecting others, delay would render the claim stale and doctrine of laches limitation will be applied.
Okay.
Insofar as the consequential relief of recovery of areas, but the fault is also attributed to you, so no interest. No interest. No interest.
Lordships, that's 3 years, 3 years, lordships, according to the judgment of
No, that is lost.
Tarsim Singh.
This is a fixed amount, not monthly. It is a fixed amount.
Yes, it was deducted in one go at that relevant point of time.
So it is, we'll say tobacco dealers.
No,
Rich man.
I understand you, lordship. It
Rich
is
man.
otherwise,
Tobacco dealers are rich men. And they are more vigilant otherwise.
no, otherwise this amount, your lordship, it's because I am only on the legal aspect.
Right. Okay. So otherwise there is no dispute.
Yes, the recovery order was issued. He has not challenged the recovery order except he wants the money to be refunded. Lordship,
Anything else?
I've only limited my affidavit to those aspects.
You have filed your affidavit.
Yes, sir.
Mm. 70 to 75.
Starts at page number 70.
Rafiq must see which paragraph?
18, Lords.
Paragraph number 18.
18.
18.
Come back. Wait.
I just wanted to point out, actually, there are two, okay, otherwise I leave it to your lordship. There are two limbs of Supreme Court judgments.
Hmm.
One line of judgment say that if there is limitation, then it cannot be, there cannot be any question of any maintaining any writ, even a writ petition under 32 or 26 in such circumstances. And the other line of judicial pronouncement say that that if there is, even if there is delay in the cases to meet the requirement of substantial justice, honorable writ courts can always exercise jurisdiction. So if I may place those judgments, perhaps.
Yes. Yes. It would. You should do like this.
Uday Shankar Avasthi dia.
Sure.
Uday Shankar Avasthi.
SSC to work out. You love SSC go.
Yes. Uday Shankar Avasthi. These are two judgments. Your lordship has already gone through Tarsem Singh, so I'm not placing it. These two judgments are in tune with what has been held in Bhailal Bhai, that delay will be fatal. So, first one is state SBI versus MJ James, 2022, 2 SCC 301, paragraph numbers 38 and 39.
38.
There the court discussed the issue of delay, lashes and acquiescence.
38.
38 and
Mr.
39.
Sharma, take your seat.
Lords.
In so and so, this court observed that if the statutory authority has not performed its duty within a reasonable time, it cannot justify the same by taking the plea that the person who has been deprived of his rights has not approached the appropriate forum for relief. If a statutory authority does not pass any orders and thereby fails to comply with the statutory mandate within the reasonable time, they normally should not be permitted to take the defense of lashes and delay. If at all, in such cases, the delay furnishes a cause of action, which in some cases, as elucidated in so and so, may be a continuing cause of action. The state, being a virtuous litigant, should meet the genuine claims and not deny them for want of action on their part. However, this general principle would not apply when, on consideration of the fact, the court concludes that the respondent had abandoned his rights, which may be either expressed or implied from his conduct. Abandonment implies intentional act to acknowledge, as has been held in paragraph number 6 of so and so. Applying this principle of acquiescence to the precept of delay and latches, this court in so and so, after referring to several judgments, has accepted the following elucidation in Halsbury's Laws of England. The statement of law has been summarized in so and so as follows. In determining whether there has been such delay as to amount to latches, the chief points to be considered are acquiescence on the claimant's part, any change of position that has occurred on the defendant's part. Acquiescence in this sense does not mean standing by while the violation of a right is in progress, but assent after the violation has been completed and the claimant has become aware of it. It is unjust to give the claimant a remedy whereby his conduct he has done that which might fairly be regarded as equivalent to a waiver of it, or whereby his conduct and neglect, though not waiving the remedy, he has put the other person in a position in which it would not be reasonable to place him if the remedy was afterwards to be asserted. In such cases, lapse of time and delay are most material. Upon these considerations rests the doctrine of latches. Then paragraph number 39, Your Lordship. Before proceeding further, it is important to clarify the distinction between acquiescence and delay and latches. Doctrine of acquiescence is an equitable doctrine which applies when a party having a right stands by and sees another dealing in a manner inconsistent with that right, while the act is in progress and after violation is completed, which conduct reflects his assent or accord. He cannot afterwards complain. In literal sense, the term acquiescence means silent assent, tacit consent, concurrence, or acceptance, which denotes conduct that is evidence of an intention of a party to abandon an equitable right, and also to denote conduct from which another party will be justified in inferring such an intention. Acquiescence can be either direct, with full knowledge and express approbation, or indirect where a person having the right to set aside the action stands by and sees another dealing in a manner inconsistent with the right and in spite of the infringement takes no action mirroring acceptance. However, acquiescence will not apply if lapse of time is of no importance or consequence. Then in the Uday Shankar Awasthi judgment, Your Lordship, in 2013 2 SCC, there section 472 of the CRPC was being discussed. I'll just read paragraph 43, which is relevant. It was in criminal jurisprudence, but approaching the court at the belated stage for a rightful cause, even for the violation of fundamental rights, has always been considered as a good ground for rejection at the threshold. The ground taken by the learned respondent number 2 that the cause of action arose on so and so and so and so, as the appellants refused to return money and other materials, articles, and record, does not have substance worth consideration. In case a representation is made by the person aggrieved and the same is rejected by the competent authority and such an order is communicated to the person aggrieved, making repeated representations will not enable the party to examine the delay. Now, this is one line of judgments, Your Lordship, where Tarsem Singh perhaps stands in the middle. Then there is another line, Your Lordship, which is completely on the other end of the spectrum, Your Lordship. Tukaram Kana Joshi. Dharnidhar Mishra or Vidya Devi. These three judgments I paragraphs Tukaram Kana Joshi, the first judgment, Your Lordship, 2013 1 SCC.
This is perhaps land acquisition.
Tukaram Kana Joshi, yes, your land acquisition. Paragraphs 11, 12, and 13. There, this distinction has also been taken care of, Your Lordship. There are authorities which state that delay in laches extinguish the right to put forth a claim. Most of these authorities pertain to service jurisprudence, grant of compensation of a wrong done to them decades ago, recovery of statutory dues, claim for educational facilities, and other categories of similar cases. Though it is true that there are a few authorities that lay down the delay in laches debar a citizen from seeking remedy, even if his fundamental rights have been violated under Article 32 or 26 of the Constitution, the case at hand deals with a different scenario altogether. The functionaries of the state took over possession of the land belonging to the appellants without any sanction of law. The appellants had asked repeatedly for benefit of compensation. The state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. There is a distinction, a true and concrete distinction between the principle of eminent domain and police power of the state. This is not otherwise relevant. Paragraph number 12, Your Lordship. The state, especially a welfare state which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the Constitution. Our Constitution is organic and flexible. Delay in laches is adopted as a mode of discretion to decline exercise of jurisdiction to grant relief. There is another facet. This court is required to exercise judicial discretion. That said discretion is dependent on facts and circumstances of the case. Delay in laches is one of the facets to deny exercise of jurisdiction. It is not an absolute impediment. There can be mitigating factors, continuity of cause of action, etc. That apart, if the whole shocks the judicial conscience, then this court should exercise the discretion, more so when no third party interest is involved. So this is relevant, Your Lordship. Paragraph number 13. The question of condonation of delay is one of discretion and has to be decided on the basis of the facts of the case at hand, as the same vary from case to case. It will depend upon what the breach of the fundamental right and the remedy claimed are and when and how the delay arose. It is not that there is any period of limitation of the courts to exercise their powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in a matter after the passage of a certain length of time. There may be a case where the demand for justice is so compelling that the High Court would be inclined to interfere in spite of delay. Ultimately, it must be a matter within the discretion of the court, and such discretion must be exercised fairly and justly so as to promote justice and not to defeat it. This was followed, Your Lordship, in the later two judgments. In 2020, first in 2020, Your Lordship, Vidya Devi versus State of Himachal Pradesh.
All are
yes, on the same line, Your Lordship. And the other one, it is in this one, it is paragraphs numbers 12.12 and 12.13. I'll not read out the paragraphs, Your Lordship. And in the other judgment, Your Lordship, in 2024, paragraph numbers 21 and 23. Perhaps now this, since he has given some indication of why the delay occurred, perhaps it will fall on Your Lordship.
We'll only take that into account. Let us see what kind of document he is annexed. So you are nearly 70 years now.
Lordship.
Okay. Invoking the extraordinary, discretionary and equitable jurisdiction of this court under Article 226 of the Constitution of India. The petitioner has instituted the instant writ petition seeking inter alia direction to the respondent Assam Power Distribution APD Corporation Limited, APDCL, to refund, to make payment of an amount of rupees 1 lakh 58,760. Comma, which amount, comma, according to the petitioner, comma, was arbitrarily deducted from the retirement gratuity of the petitioner after his retirement from service on superannuation on 31/12/2013. Full stop. Para. The petitioner was in petitioner joined service in the Assam, in the erstwhile Assam State Electricity Board, within bracket ASCB. And after, what is disbanding or what?
Your Lordship, as per the 2003 Electricity Act, boards were the system, the earlier, as per the old act, there was electricity boards which took care of generation, distribution and transmission. That was trifurcated into distribution companies, generating companies and
After-
transmission companies.
After, what is, after disbanding?
After trifurcation.
After trifurcation of the ACB pursuant to the Electricity Act 2003 into 3 entities, comma, the service of the petitioner came to be under the Assam Power Distribution Corporation Limited. Full stop. During his service career, comma, the petitioner rose through the ranks and finally on 31/12/2013, comma, he retired from service of the APDCL on reaching the age of superannuation of 60 years on 31/12/2013. Full stop. Having acknowledged satisfactory service rendered by the petitioner.
Perhaps it is 1-1 only because the retirement order says that he is entitled to pension from 2-1.
1-1. That is what some confusion. Otherwise, one should not retire on 1-1.
Then will be one missing day otherwise, Your Lordship.
1/1/2014 করে দিব, huh? 31/12/2013 ওঠাই, huh? Having acknowledged satisfactory service rendered by the petitioner or rose through the ranks বুলি কৈছিল ন? At the time of his retirement on superannuation, comma, the petitioner was serving in the post of
engineering subordinate.
Hmm.
Page 19.
What it mentioned? Engineering subordinate, that's Roman 2. Within bracket E stroke S, that's Roman 2. Full stop. Subsequent to his retirement on superannuation, comma, the competent authority in the APDCL issued an order, office order, on 19/8/2014, sanctioning pension, comma, commuted value of pension, and retirement gratuity. Full stop. By the office order dated 19/8/2014, comma, the petitioner was sanctioned pension at 11,890 per month with effect from 2/1/2014 prior to the date of withdrawal of commuted value of pension, page 19 also, and thereafter at rupees 7,927 per month till his death or restoration of full pension, comma, whichever was earlier. Full stop. The office order also sanctioned an amount of rupees 4,66,525 towards commuted value of pension. Full stop. Insofar as retirement gratuity is concerned, comma, the petitioner was paid an amount after adjustment of outstanding liabilities. Full stop. Though an employee of the APDCL was entitled for a retirement gratuity of rupees 7 lakh, comma, the petitioner was not granted the entire amount of rupees 7 lakh, as the petitioner, full stop, it was mentioned that the petitioner had an outstanding liability of rupees 1,58,760 because of excess withdrawal of pay and interest on overdrawn and interest on it, which was credited to ZPF account as per the provisions of revision of pay rules of 1992 and 97. Full stop. The office order also mentioned about family pension. Full stop. Since the petitioner is surviving as on date, comma, there is no necessity to dilate on the aspect of family pension. Full stop. Para. I have heard Mr. R. Sharma, Learned Counsel for the petitioner, and Mr. K.P. Pathak, Learned Standing Counsel, APDCL, for all the respondents.
I'm not appearing for respondent number 2, Your Lord.
Okay. Okay. You are only appearing for
Respondent numbers 1, 3, 4, and 5, Your Lordship.
1, 3.
2 is AGCL. At that relevant point,
Okay.
AGCL was in charge for handling the pension related matters, Your Lordship, of all the 3 companies. So he has been implemented. as
For
a-
the respondent authority in the APDCL. Full stop. Para. Mr. Sharma, learned counsel for the petitioner, has submitted that it was at a time of the petitioner's retirement on superannuation, the respondent authorities checked the payments made to a salary of the petitioner during his service period. And it was detected that during the period from 2006 to 2014, there was erroneous fixation of pay full stop. After calculation, the respondent authorities had arrived at a figure of rupees 1,58,760, and without any kind of information to the petitioner, the respondent authorities are deducted the said amount from the retirement gratuity of the petitioner. Full stop. It is submitted that there is no role attributable to the petitioner in such erroneous fixation of pay. Full stop. During the subsequent period after retirement, the petitioner was a petitioner had been undergoing medical treatments at various health facilities in within the state as well as outside the state. Post of for as the petitioner is a chronic patient suffering from bronchial asthma, para 6, hypertension, diabetes, obesity since the year 2010. He had to go for medical treatment. Liver, GB, pancreas, spleen, kidneys. At various health facilities, including Apollo Hospital at Chennai. Post of. He has submitted that though the petitioner ought to have objected to such arbitrary reduction of the aforestated amount within a reasonable period of time, his health condition did not permit and prevented him from raising any complaint within a reasonable period of time. Full stop. Here it is further submitted that even a claim at even such a claim at this stage should not be thrown away, should not be rejected as any rejection would be harsh and onerous for the petitioner at this big end of his life. When he is suffering from various ailments. First off, Mr. Sharma has, in support of his submissions regarding arbitrary deduction of the amount, has referred to the decisions in এটা আছে ৰুচি ভাই জগদীশ ভাই পাঠক আৰু তাৰ আগতে লিখিব ষ্টেট অফ পাঞ্জাব এণ্ড আদাৰ্ছ ৰফিক মাছি চোপ্ৰা ৰফিক মাছি দেন Konisk Sinha and another versus State of West Bengal and another. 2025 INSC 278. Para Mr. Pathak Learned Standing Counsel. Appearing for the respondent, APDC authorities have submitted that there was inordinate delay on the part of the petitioner to approach this court, claiming the direction, claiming the relief first off, he has contended that the claim of the petitioner is, in essence, a money claim. And in respect of such a money claim, comma, the ordinary period of limitation, the period of limitation, the law of limitation for recovery of money is ordinarily applicable. Full stop. From the order date, office order dated 19/8/2024, comma, it was evident that the amount of rupees 1,58,760 was adjusted because of payment of excess amount to the petitioner. Full stop. Despite knowing the reason for adjustment, comma, the petitioner had waited for about a decade to about a decade, and the same clearly amounts to waiver and acquisition. Full stop. In support to buttress his submissions, comma, Mr. Pathak has referred to the decisions in State of Madhya Pradesh versus Bhailal Bhai. And you said MJ James. And Dhonidhar, sorry. Uday Shankar.
Against that proposition.
Uday Shankar.
Uday Shankar.
Avasthi. Full stop. He has also submitted that there are a separate line of decisions on the aspects of waiver, comma, acquisitions, etc. As can be seen from the decisions in Tukaram Kanna Joshi, Vidya Devi, Dharanidhar Mishra. Full stop. Para. Should I record your prospective one? Rafiq Masi? Record.
Lordship, otherwise paragraph 10 of Rafiq Masi itself says that when the earlier judgments are under Article 142. So perhaps I'm not pressing that ground, your Lord.
From the office order dated 19/8/2014. Comma, it appears that the figure at rupees 1,58,760 was arrived at by totaling four figures of rupees 53,416, comma, rupees 48,784, rupees 28,056, and 28,504. Towards excess draw or pay drawn and interest on overdrawn and credited to GPF account in respect of revision of pay rules of 1992 and 1997 respectively. Full stop. By a subsequent communication dated 8/9/2024, comma, the said amount of rupees 1,58,076 was deducted as outstanding liabilities from the otherwise from the petitioner's otherwise entitled retirement gratuity amount of rupees 7 lakh. Full stop. On the respondent authorities had found that the pay fixation of the petitioner had found upon checking pay fixation of the petitioners from time to time that the pay fixation with effect from 1/1/2006 was wrongly made, and it was decided that the overdrawn amount were to be worked out and entries were to be made in the service book afresh. Full stop. After carrying out the exercise, comma, the respondent authorities had arrived at the figure of rupees 1,58,760. Full stop. Para. From the communication, comment communication, page 21, dated 28/2/2014. Addressed by the respondent number 5 to the respondent number to his higher authority. It is evident that the the matter of the matter of wrong fixation of pay was attributable to the respondent authorities. Full stop. It is not the case of the respondent APDCL authorities that there was any kind of misrepresentation or fraud on the part of the petitioner in such erroneous fixation of pay. Full stop. Was the meaning thereby, comma, it was solely due to a wrong fixation of pay made by the respondent APDCL authorities. The petitioner was provided with a pay which otherwise were paid amounts towards pay which were otherwise not entitled to him. Full stop. Para. The petitioner joined service I think you were grade 2 or 3?
Grade 2, Lordship.
Grade 2.
Lordship.
Initially,
Initially 2, Lord.
petitioner during his service career rose through the ranks to reach ultimately the rank of subordinate ES2. Post of para. In Rafiq Masih Vaidasa Supra, comma, the Honorable Supreme Court has had the occasion to deal with the right of the state as employer to recover amount paid in excess to employees. Full stop. And recovery of amount paid in excess without any fault or misrepresentation attributable to such employee, to such employees. Full stop. It has been held as a principle that benefit of non-recovery cannot extend to those employees It also considered the hardship likely to be caused to the employees in case of recovery is directed vis-a-vis equal right of employer to recover. Full stop. It considered, the Honorable Supreme Court considered a number of situations and instances when recovery does not appear to be appropriate. Full stop. Though not exhaustive, comma, the Honorable Supreme Court has enumerated a number of situations of hardship in the following manner. Paragraph 18. 18, right? 18.
Paragraph 10, Your Lordship, that aspect that even the earlier pronouncements are under law under Article 142, that is stated, Your Lordship.
Ten লিখিব আৰু 18 লিখিব। In Hilal Vai Supra, comma, Honorable Supreme Court, while observing that the law of limitation do not as such apply to the granting of relief under Article 2226 of the Constitution, comma, the court should keep in mind the maximum period fixed by the legislature for granting relief of recovery of money by a suit in a civil court. Full stop. It has been observed that the time within which a relief by a suit in a civil court is to be brought may ordinarily be taken to be a reasonable standard by which delay in seeking remedy under Article 226 can be measured. When the delay is more than the said period, comma, it would be proper for the court to hold that it is unreasonable. Full stop. The period of limitation prescribed for recovery of money paid by mistake under the Limitation Act is 3 years from the date when the mistake is known. Full stop. It has been submitted on behalf of the respondent APDCL authorities that since the petitioner had the knowledge regarding the factum of recovery as far back as on 19/8/2014, comma, it is not open for the petitioner to wait for such a long period. Full stop. Does the repetition and does the repetition suffers from delay in laches as well as waiver as regards the claim. Full stop. The decision in Uday Shankar Avasthi as tailwinds is a decision under is a decision dealing with continuing offense. Under section 468 and section 472 of the Code of Criminal Procedure 1973. Okay, Mr. Pathak and Sharma will come back at 2.
In this Pathak matter, the Council for the Coal India Limited, they made a mention in the morning.
Yes.
Because the lawyers were in outstation. But it was fixed on 4th of September. I have some difficulty on 4th September. Could it be on 2nd?
Second, we have posted many matters. Some other date. It is not 4th.
Can it be taken up on a motion day? Or even 3rd is also acceptable.
We don't know what is the business of the court. And we can take, yes, on 9th. We can put it on 11th then, 11th. Correction করে দিব, correction করে দিব, sign করিয়ে দিছুন। Already signed, but okay. I'll do the correction.
Let it be on 4th. In case they have some difficulty, then we'll accommodate.
Okay. in Tarsim Singh, Supra, the Honorable Supreme Court discussed as elaborately discussed on the principles underlying quote unquote continuing wrong and quote unquote recurring stroke successive wrongs, which can be made applicable to service law disputes. Full stop. The delay was about 16 years in Tarsim Singh in approaching the courts seeking relief for arrears. Full stop. The Honorable Supreme Court has elucidated some exceptions to the has summarized the issue in the following words, paragraph 7. The decision in Tarsim Singh the ratio in Tarsim Singh has been followed subsequently in a number of decisions, including Rishi Bhai Jagdish Bhai Pathak, MJ James is on what point?
James, your lordship, it is on the difference between waiver, delay and latches and acquiescence on one side, your lord. Paragraph numbers 38 and 39 to 41. That delay and latches, your lordship, may not extinguish the right, but the remedy is definitely extinguished.
It is a settled proposition that the state, is a welfare state. Is governed by the rule of law. Full stop. Where it is said that law of limitation is not
That
applicable
is-
in repetitions.
Is not applicable. That is said in your lordship, Tukaram Kana Joshi, your lordship.
Tukaram.
Yes, your lord.
It has been held in Tukaram, Kana, Joshi and others, to the effect that delay and latches is adopted as a mode of discussion, is normally adopted as a mode of discussion to decline exercise of jurisdiction to grant relief. But it is still open for a court to exercise judicial discretion and such discretion is dependent on facts and circumstances of the case. Full stop. Delay and latches is one of the facets to deny exercise of discretion, but it is not an absolute impediment. Full stop. There can be mitigating factors, continuity of cause of action, etc. Full stop. Therefore, the court should exercise the discretion court while exercising the discretion shall keep in consideration as to keep in consideration the factor whether with the exercise of discretion any third party interest already settled is going to be unsettled or going to be unsettled. Full stop. question of condonation of delay is one of discussion and has to be decided on the basis of the facts of each case, as each case and as the facts and circumstances of each case vary from the other case, any other case. Full stop. The exercise of discussion is also dependent upon factors also dependent upon regions, when and how the delay had arisen. Ultimately, it is a discretion of the court which is to exercise fairly and justly to promote justice and not to defeat it. No hard and fast rule is laid down as to when the High Court should refuse to exercise. No, High Court exercise this or refuses to exercise its discretion in favor of a party who moves it after considerable delay. In the event the claim by the applicant is legally sustainable, delay should be condoned. Full stop. Where circumstances justifying the conduct exist, any period of delay, then the relief claim should not be denied on the sole ground of delay or laches when substantial justice and technical considerations are pitted against each other. It is the cause of substantial justice which is to be preferred, as the other side cannot claim to have a vested right in the injustice being done because of non-deliberate delay. Full stop. Where? as adverted above, the case in hand is not a case where the respondent APDCL authorities have made out a case that the fixation of pay of the petitioner for the reference period at a high amount is attributable to any act of misrepresentation or fraud on the part of the petitioner. Full stop. The petition, the pension and other retirement benefits are extended by the employer to an employee for long and dedicated years of service. Extended full stop. It is already found out that the petitioner having retired on reaching the age of superannuation of 60 years on 1/1/2024. 14. Full stop. Subsequent to his retirement, the petitioner has been undergoing medical treatments for a number of ailments. As on date, the petitioner is about 70 years of age and is in need of is in need and there appears to be constant need of a medical expenditure. First stop. The recovery of the amount of rupees so and so towards excess payment has visited the petitioner with harsh consequences. Full stop. Allowing in such peculiar facts and circumstances, allowing the employer who has to act as a model employer, to retain the said amount only on the ground that a petition was paid the same amount towards excess pay, etc., due to erroneous fixation of pay under the reference period, appears to be a measure which is harsh and onerous. Full stop. so far as the amount of so and so is concerned, comma, the respondent authorities as the employer is the effect of directing the respondent judicial authorities as employer to refund, to disburse the amount of so and so is not going to affect it in comparison to the sucker, the petitioner will have if the amount is disbursed to him. Full stop. Para. In the fact situation, in the above situation obtained in a case, comma, this court is of review that a direction is called for disbursement of the amount of rupees so and so by the respondent employer, that is, comma, the judicial authorities to the petitioner. Full stop. Accordingly, comma, it is directed that the respondent authorities, the judicial authority, shall make payment of the amount of rupees so and so to the petitioner within a period of 3 months from the date of submission of a certified copy. 3 months, that will do.
Yes, Your Lordship.
Non-submission is not required, certified copy. Full stop. Since there is long delay on the part of the petitioner also in seeking remedy, and this order is passed, this direction, and a direction is made taking into consideration the equitable consideration exercising discretion, comma, no order is made, no direction is made as regards the claim of interest.
Deeply.
Lordships, is failure to make the payment within the stipulated period, Lordship.
3 months.
3 months, failure to make the payment, may I pray for interest accrued hereafter, Lordship. Interest, Lordship.
Okay. And it is made clear that in the event of failure to make the disbursement of the amount of rupees so and so within a period of 3 months from today, the same would entail
3
interest.
months from the supplier certified copy, I think.
Since an intra-party order.
Very well, Your Lordship, very well, very well. I'll communicate it
You
today.
convey it.
Very well.
Same would entail interest at 6% per annum. From the date of this order.
Obliged.
The requisition is disposed of in the appropriate terms, no cost.
Lordship, in one place, I just checked, even I got confused. It is Assam Power Distribution Company, Your Lord.
Company.
Other two companies, they are called corporations.
Okay.
This is Assam Power
Assam
Distribution Company.
Power Distribution Company Limited. I'll make some correction to 3 days. Because it is very difficult to read through all the judgments in the court.
Because this is, there is some ambiguity on this issue. That is why I placed both the.
Right.
Yes. Sir. Obliged.
Item 39.
My pleasure, Your Lord.
Affidavit filed.
Yes, affidavit has not been filed, but we have the instructions.
Huh?
We have the instructions. If it has not been filed yet.
What is the nature of relief claim?
He wants the minimum pay scale as per the.
Huh?
He wants the benefit of Upendas, minimum pay scale.
Then you file your response.
Other than.
What prevented you?
Yes. Our instruction says that he, being a contractual employee, governed by the contract, is paid a fixed remuneration when he can claim for a minimum pay scale. Furthermore, Lordship, Upendas is taken into consideration as per the direction of Upendas in para 22. The tenure of service is to be counted from 1/8/2017. In this case, it's not 10 years or more than 10 years for the case of petitioners. Then the benefit also will be applicable.
Actually, a contractual basis. So it was a contract basis appointment. Pursuant to an advertisement, fixed remuneration.
Regular
Fixed remuneration.
fixed remuneration.
Then with what basis you are claiming?
Hello?
On what basis you are claiming?
My lord, as per this Upendas rules, we are working since 2009-10, my lord.
What is Upendas?
Plus, more than 10 years service, they can claim regularization or minimum scale, my lord. And also the judgment of Supreme Apex Court, my lord, Jagjit Singh, equal work, equal pay. We are working like a permanent.
Heartening to learn that the state government has agreed not to come. Whether contractual employees are covered?
No,
Yes, my lord.
Huh?
no, Lordship, Upendas doesn't talk about any
Master
contract.
role, work charge and casual worker.
Lordship, other than that also, if Lordship may peruse para 22. At the last part, I may read. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in light of decision of the Supreme Court in State of Punjab versus Jagjit Singh, also direct the state government to pay minimum of pay scale to the muster roll workers, work charged workers, and similarly placed employees working since last more than 10 years, not in sanctioned post, with effect from 1/8/2017. In this case, the petitioners are, if it is counted from 1/8/2017, the service of the petitioners are not more than 10 years. Instead, it is less.
2019,
9/10 of
No.
2017.
Council, what, you
25.
this was
More than
rendered on
14
AC
15 years, my lord.
2020, 2017,
Yes,
Upendas,
Yes,
right?
they were appointed in 2010. So the tenure is 7 years.
It is on 8/6/2017.
Yes, 1/8.
And division bench said that you make the payment at minimum of the pay scale with effect from 1/8/2017.
Yes, 1/8/2017, preceding his tenure of service. That is, it used to be counted from the date of engagement, that is 2010 to 2017. And it is around 7 years, not 10 years.
Perhaps the principle is that there should be minimum 10 years.
Yes. In 10 years or more.
Now, as on date, they are 10 years.
As on date, it is 10 years, but
Right, whether this is to be interpreted like that or 10 years is the main principle.
10 years is the main. 10 years from the
10
day.
years is the main principle.
Yes.
I think rendering 10 years service. But here, how many? This is an association or what?
No, my lord, there is the association, but come before this.
Mr. Council, you are standing council, Panchayat.
No, Lordship, I am appearing on behalf of Mr. S. Datta.
You file your response. Earlier, you sought time for filing response
Yes, Lordship.
to file affidavit.
Let them file it.
Why don't you file affidavit? Mr. Mr. M.H. Ansari, Land Council Board of Petitioners, and Mr.
A.K. Ghosh.
A.K. Ghosh, Land Council representing Mr. S. Datta, Land Standing Council Panchayat and Rural Development Department for the response number 1, 3, and 4. Post up. How much time Mr. So-and-so Land Council has submitted that he has received the necessary instructions to file the counter affidavit and has thus sought for further 2 weeks' time to file the counter affidavit on behalf of the respondent number 1, 3, and 4. Post up. The praise allowed, release the case after 2 weeks. On date 2 weeks by the office.
Pick the date, my lord.
Oh, I'll not pass any order on date.
God bless you.
Huh? Matiduk, huh? UPSC bail to know.
Item 35.
No, Satendra or BNSS B CRBC. Yes, which one? You, that's it. What are the grounds? WhatsApp.
WhatsApp, my lord.
One is WhatsApp. And one is
One is lordship after lordship elapse.
notice under section 179.
179. But that provision is for to call the witnesses.
Also regarding WhatsApp, my lord, I took the instruction, my lord. What has happened, my lord? This person got bail, my lord, that day. He appeared there. He was not well. In fact, my learned friend also stated, my lord. So police thought, my lord, police didn't knew that he was traveling back to Guwahati. So because it is a offense related to financial scam, my lord. So because to link those accounts and all these things, my lord, they thought that because since he is not well, and they are under the impression that he was in support, So, my lord, my lord, without any bad intention, my lord, they set the notice so that that particular day he can appear and come back to Guwahati, my lord, because the distance was, my lord, far. They didn't knew that he came back that day itself to Guwahati, my lord. Then this was also, my lord, after that, my lord, police are not, in fact, contacting him, my lord, because they knew that he is not well, my lord.
Anyway, otherwise, only issue is that on 6th August,
Yes, my lord.
by WhatsApp,
Yes, yes.
the notice has been sent. We are not dealing with other issues.
Yes,
It
my
is-
lord.
it is case
That is not
because
permissible.
the bail was granted
Granted.
on the ground that grounds of arrest was not
Yes,
furnished, right?
yes.
And still it is a financial,
Scam.
related to a financial scheme.
Yes, my lord.
Is otherwise he is required to be
Present, my lord. As and when
required
required.
to join the investigation.
Investigation.
Assist the investigation.
Yes, ma'am.
Now, so far as 179 is concerned, it includes an accused also. Right? Any person knowing
Yes, ma'am.
the acquainted with the facts of the case. That has been interpreted, I think.
Yes, on page 443, my lord.
So that is that you cannot avoid.
I am, otherwise I am always ready, Lordship. But their intention, because at 12:20 that was said.
We are not going into intention.
Yes, Lordship. But
we are not going into intention.
And the conditions which was, Lordship.
Well, that has been admitted. That has the police also said that, my lord, they thought this person is not well. So before he returns to Guwahati, they can take some statement, my lord.
Paragraph?
My lord, it's 36, 35, my lord. Page 443. It starts 35. 443. Hello.
But this is 161.
My lord, regarding why, my lord, initial here, first 35 paragraph itself. So the first point to be decided is whether the police have power under section 160 and 161 CRPC to question the person who then was or
The
in.
first
future-
point to be decided.
Yes, my lord, because 161, those person, obviously they will have to call by under 160, my lord. Then they will come and the wording are same, my lord, any person.
So the first point to decide is the power. Apart from this paragraph, any other paragraph?
Well, this is the, because this judgment was delivered dealing with different points, my lord. Regarding this point, this is the paragraph, my lord, 35, 36.
In 1972, SCC seven for it, Mohabir Mondol. Where the petitioner has approached this court seeking to invoke the inherent powers under section 528 of the Bharatiya Nagorik Suraksha Sanhita 2023. Agreed by a notice issued under notice issued under section 179 BNSS. On 6/8/2025, seeking through WhatsApp by the IO of the case, seeking his presence before him on that very day. Full stop. Para. I have heard Mr. N.H. Borvia, learned counsel for the petitioner, and Mr. R.R. Kosik, learned additional public prosecutor for the respondent state. Full stop. Mr. Borvia, learned counsel for the petitioner, has submitted that the petitioner has been considered as an accused in connection with Sapor Police Station case number 119/2020 and was arrested during the course of investigation of the said case. Full stop. On an application being made for his release on bail, the petitioner was granted bail in connection with Sapor Police Station case number 119/2025 by the Court of Learned Judicial Magistrate First Class, Bilahipara, on 5/8/2025. Full stop. It has been submitted that the impugned notice, dated 6/8/2025, was served upon the petitioner at 12:20 p.m. on 6/8/2025 through WhatsApp, whereby the petition was directed to appear before the IO of Sapor Police Station case number 119/2025 at 10 a.m. on 6/8/2025. Full stop. Mr. Borvia has made twofold submissions, firstly, a notice under section 179 BNSS could not have been served upon the petitioner as the petitioner has been arraigned as an accused, has already been arraigned as an accused in the case, and therefore, he cannot be considered as a witness as the provisions of section 179 BNSS is meant for only witnesses. Yes. And secondly, a notice under section 179 BNSS could not have been served upon the petitioner through WhatsApp, as such mode of service is not contemplated for a notice under section 179 such a mode of service is not contemplated under the provisions of the BNSS. Mr. Kosik, the additional public prosecutor, has responded by stating, by submitting that an accused can be embraced within the ambit and scope of section 179 BNSS, which provision is perimeter area to section 160
Yes.
of the Code of Criminal Procedure 1973. Full stop. An accused, like a witness, is also a person who appears to be acquainted with the facts and circumstances of the case. And therefore, the petition cannot avoid the obligation from the umbrage of section 179 BNSS only on the ground that he has already been arraigned as an accused because of his arrest. To stop. Mr. Kaushik has further contended that, has further submitted that as the petitioner was allowed to go on bail by an order dated
Five eight.
5/8/2022.
5/8/2025, the eye of the case deemed it proper, in the interest of an expeditious investigation, to seek presence of the petitioner before him on the next date of his release, that is on 6/8/2025. Notwithstanding the facts stated on without having any knowledge about the facts projected in this criminal petition, right? Full stop. Para. On the submissions, on the contentions, and the submissions made by the Lieutenant Counsel for the parties, two issues have arisen for consideration. So, firstly, whether the petitioner, whether an accused fall within the provisions of section 179 BNSS. And secondly, whether a notice under section 1 79 TNSS can be served upon an accused to Acha. Without adopting to the normal mode of service set forth in the provisions of PNSS for such kind of service. Full stop. Para. Before a deliberation on the issues involved, comma, it appears appropriate to narrate the preceding events briefly. Post para on one 2025, comma, a first information report FIR was lodged before by one Nirmal Das as the informant before the officer in charge, Sapor Police Station, stating inter alia that he was made to learn that a priority investigation was being undertaken by ED, quote unquote ED.
That was
ED,
some
ED
WhatsApp number was.
Huh?
Some WhatsApp number was stated. Lord.
ED.
Yes.
And ED. And by messages and regular video call conversations, comma, the informant was asked to make payment of rupees 1,67,93,385 to ED. Post as asked for, the petitioner had made payments of a total amount of rupees 1,67,00,000 93,385 to ED during the period from 21/01/2025 to 9/5/2025. Full stop. The petitioner, the informed, had further stated that he was told that after submission of all the money receipts by which he made payments to ED would be refunded to him after 3 working days to his bank account maintained at Sapor branch of the State Bank of India. Post stating that the said amount the informant had deposited was his whole life's savings amount and his daughter's future would be dependent on this amount, comma, the informant requested for an investigation into the matter as the amount comma 1,70,039,444.20 deposit by him in favor of ED was not refunded. Line to likhibo. Other than, in addition to the amount of rupees 1,67,93,385.20 is 18 or figure. He deposited other amounts also which ultimately totaling 1,70,39,444.20. Para on receipt of the FIR, comma, an inquiry was undertaken by a sub-inspector of police attached to Sapor police station at the instruction of the officer in charge. And upon inquiry, comma, a report was submitted that the offenses committed are cognizable offenses. So someone received the report, comma, the FIR has been registered as Sapor police station case number 119/2025 under section 61 within bracket 2 stroke 318 within bracket 4 stroke 336 within bracket 3 of the Bharatiya Nyaya Sanhita and NSI Sub-Inspector of Police has been entrusted to carry out the investigation on 1/8/2025. Post of para. It was on. The petitioner has claimed that he is a tax consultant by occupation, and he helps in filing of income tax return, comma, GST return, etc. Also, he resides in a rented house located at Hatigarh. Which place? You said? Hatigaon, comma, Guwahati. Full stop. Para. It was at about 6 o'clock, means morning or evening?
Morning, Your Worship.
It was at about 6 a.m. on 4/8/2025. The petition was picked up from his rental house by a team of police personnel from Sapor Police Station. And he was taken to Sapor Police Station. In the evening hours on that day. Post up. On reaching the Sapor Police Station, the petitioner was arrested at around 7:30 p.m. on 4/8/2025 by serving an arrest memo and notice under Section 48 B and SS to his younger brother. Full stop. It has been contended on behalf of the petitioner that the petitioner was arrested without serving any grounds of arrest in writing. As a result, the petitioner was unaware about the reasons for his arrest in connection with Sapor Police Station case number 119/2025. When the petitioner was produced before the Court of Learned Judicial Magistrate, First Class Bilakipara Dhubri, on 5/8/2025, with a forwarding report of event date comma, it was mentioned before the learned court that by the police personnel that upon analysis of the bank account whose bank account? Account, comma, an amount of rupees 28,05,5,175 was found credited to the account of one Hafizur Rahman to RTGS. Hafizur Rahman to one account belonging to one Hafizur Rahman at Bandhan Bank through RTGS from the bank account of the informant. Para. When an application for bail was moved on behalf of the petitioner, primarily on the ground that there was effectively no grounds of arrest. No, was moved, comma, was moved before the learned so-and-so, court of so-and-so on 5/8/2025, comma, the petitioner was allowed to go on bail of rupees 30,000 with one surety of the like amount. Full stop. In the order stated, no, sorry, it was contended on behalf of the petitioner that in the forwarding report, it was mentioned that quote unquote, page 24, quote, text messages of suspicious transactions from different person and a business firm is seen, unquote, as the reason for seeking police remand. Post op. It was asked before the court that the grounds of arrest were fake. And therefore, continued detention. Detention by petition would be illegal. Post op. Para. The petitioner has stated that after the court, learned court, allowed the prayer for bail, the petitioner was released from custody at around 6:30 p.m. on 5/8/2025. After being released from custody, the petitioner went to Sapor police station at around 9 p.m. on 5/8/2025. Take his wearing apparels. Post op. Thereafter, he proceeded to Guwahati and he reached his rental house at Hatigaon at around 3:30 a.m. on 6/8/2025. Post op. As the petitioner was suffering from various ailments, he visited his doctor at Aija Wellness Center, GMCH Road, Bangagor, Guwahati, in the evening hours of 6/8/2025. And the doctors, after examination, advised him for rest and advised him for certain medical investigations and for rest. Post op. On 6/8/2025 itself, 6/8/2025 and 7/8/2025. The petitioner had done the medical investigations as advised by his doctors. Post op. Para. The impugned notice was under section 179 BNSS. In the petitioner has been shown as the noticee. First of, it is stated that it is mentioned that the notice has been made in exercise of the powers conferred under subsection 1 of section 179 BNSS. By the notice, the petitioner has been was directed to appear before the investigating officer of the case, that is, Co-District Superintendent of Police, Bilahipara, at 10 a.m. on 6/8/2025 at Sapor Police Station. Full stop. In the notice, it is further mentioned that during the investigation of Sapor Police Station case number 119/2025, it is revealed that there are reasonable grounds to question the petitioner to ascertain facts and circumstances from him. Full stop. This served through WhatsApp is mentioned in the notice itself.
Yes, Lordship, in the notice itself.
Yes, my lord.
Below, sir.
In a what can be noticed from what can be noticed from the what can be discernible from the notice, impugn notice, is that the notice has been shown to be served through WhatsApp. Full stop. To your younger brother?
Yes, Lordship.
Not to you?
Not to me, because my phone was already seized.
Okay. The notice has been sent to the WhatsApp number of the petitioner's younger brother at 12:20 p.m. on 6/8/2025. Full stop. The petitioner has, Mr. Borguia has submitted that the petitioner's mobile number has already been seized in connection with the investigation of Sapor Police Station case number so and so. Full stop. Para. Subsection 1 of section 179. No, entirely. Section 179 of the BNSS has a nominal heading, quote, police officers' power to require attendance of witnesses, unquote. Full stop. Subsection 1 of section 179 has provided that any police officer making an investigation under chapter Roman 13 may, by order in writing, require the attendance before himself of any person being within the limits of his own or any adjoining station, who, comma, from the information given or otherwise, comma, appears to be acquainted with the facts and circumstances of the case, semicolon, and such person shall attend as so required. Full stop. The as the two provisos to subsection 1 of section 170, as the two provisos to section 179, in bracket 1, are not relevant for the purpose of the case, comma, the same are not adverted to. Full stop, para. The provisions of section 179 PNSS are perimeter to section 160. CRPC. Which had the same nominal heading, quote unquote, police officers power to require attendance of witness, unquote. Post. That apart, comma, there is no difference in section 179(1) PNSS and section 160 within bracket 1 CRPC. Post. Section 160 within bracket 1 CRPC had one provider, unlike section 179 1 BNSS. So be that as it may. The provisions of the words, comma, quote unquote, appearing, quote unquote, withdrawn hobo, any person appearing in section 160 within bracket 1 CRPC came up for consideration in Nandini Satpathy versus PL Dani and another, reported in 1978 to SCC 424. Full stop. The point taken up for decision was whether the police had power under section 160 and section 161 of the CRPC to question a person who, then was, or, in the future might incarnate as, an accused person. Full stop. It was held that, quote unquote, any person would include persons then or ultimately accused. It was observed that, quote, any person supposed to be acquainted with the facts and circumstances of the case, unquote, would include an accused person who fills that role because the police suppose him to have committed the crime and must, therefore, be familiar with the facts. The supposition may later prove a fiction. Not like it is held. It has been observed that the marginal note, quote, examination of witnesses by police, unquote, did not clinch the matter by observing that a marginal note might could clear ambiguity, but it would not control meaning. Full stop. The supposititious accused would figure functionally as a accused, full stop. Therefore, quote, to be a witness, unquote, from a functional angle, is to impart knowledge in respect of a relevant fact. Full stop. The dichotomy between witnesses, quote unquote, and accused, quote unquote, used as terms of art, would not hold good. As to hold otherwise would amount to holding up investigative exercise, since questioning of a suspect was desirable for detection of crime, Posted. As the the interpretation given to the words, quote unquote, any person appearing in section 160 within bracket 1 CRPC, comma, in the considered view of this court, comma, is also applicable to the words, quote unquote, any person appearing in section 179 1 BNSS, meaning thereby, comma, any person appearing in section 179 1 BNSS includes an accused also. So therefore, it cannot be. This court is not persuaded to hold that the notice dated 6/8/2025 issued the petition is outside the purview of 179 1 BNSS. Full stop. Para. Admittedly, comma, the notice was sent to the petitioner as the noticee through WhatsApp, and that too, comma, to the mobile number of the petitioner's younger brother. Full stop. Be that as it may, that's a quasi. In any view of the matter.
Moreover, the conditions which were, which was inputted lordship in the notice, but that was also not for 179 law. That
My lord,
condition
this is a
which
standard,
did not have-
standard format, my. This is a standard. format.
We'll not dilute it.
Yes, it is silent law.
We will, at an appropriate case, we'll do that. Because this condition is, we are saying, we'll be saying that this is not proper. নালাগে এইটো। অ'। এই সত্যেন্দ্ৰ কুমাৰ আনটিলটো চাওঁ 2022 নালাগে। The mode of service of a notice under section 41-A of comma CRPC stroke section 35 BNSS and similarly a notice issued under section 160 similarly, comma, notices issued under section 160 CRPC stroke section 179 BNSS and section 175 comma CRPC stroke section 195 BNSS have come up for consideration before the Honorable Supreme Court. In Sotender Kumar Antil versus Central Bureau of Investigation in another. Full stop. In an order passed in miscellaneous application number 2034-2022 in MA, sorry, in MA 1849-2021 in special repetition within brackets CRL number 5191/2021, comma, the Honorable Supreme Court has made the following directions. Page pencil mark edition. Subsequently, in another interlocutory application, IA number 63691 of 2021, comma. Clarifications were sought with regard to the above directions. Full stop. While answering, comma, the provisions of section 35 of the BNSS has been adverted to. Full stop. It has been observed that section 35 BNSS has provided for arrest of persons by the investigating agency, comma, ensuring that the concerned person appears before the investigating agency and cooperates with the investigation. Full stop. The provisions delineates the prerequisites that must be fulfilled before a person can be arrested without a warrant, comma, keeping in mind the objective of safeguarding the liberty of an individual. First stop. The legislative intent behind the provision is that of restricting arbitrary arrest. Full stop. Section 35(3). The Honorable Supreme Court has taken note of section 35(3) of the BNSS, which mandates the service of a notice whenever the investigating agency, comma, on the basis of a reasonable complaint, comma, credible information or suspicion, determines that a person may have committed a cognizable offense, comma, but does not deem the arrest of such person necessary. So in such a scenario, comma, the investigating agency is mandated to issue a written notice directing the person to appear before it, comma, or at such other place as may be specified in the notice. Full stop. Section 35(4) of the BNSS imposes a duty. লিখি দিব এটা আছে হ্যাঁ কোড কৰি দিব নহ'লে কোটে কৰি দিব পেৰা 20, 21, 22, 23, 24, 25, 26, 27, 28. As like a notice under section 35 BNSS No, এনেকে লিখক। Section a notice under section 175 BNSS would have an immediate bearing on the liberty of the individual in case of its non-compliance comma, it has been held that electronic communication is not a valid mode of service under section 35 of the BNSS. Full stop. Introducing a procedure into introducing a procedure thereby treating electronic communication as a valid mode of service of notice under section 35 of the BNSS would be violative of its intent as it has not been specifically provided for by the legislature. Full stop. Para. Similar to the consequence. No, the section 179(1) has also provided that a noticee who has been served with a notice shall have to attend as required. Full stop. As non-compliance to the direction is likely to visit the noticee with consequences which may ultimately result into consequences, comma. The the sending of the notice by sending of the notice in electronic, by way of electronic mode, way of, through WhatsApp or other electronic mode cannot be considered or recognized as an alternative or substitute to the mode of service recognized and prescribed under BNSS 2023. First of as such, the impugned notice sent through WhatsApp to the petitioner is to be treated as an illegal one, and it is accordingly observed. Full stop. The investigating officer of the case, Sapporo Police Station, case number 119/2025, cannot act any further on the basis of the said impugned notice dated 6/8/2025. Full stop. Para. In view of the above discussion, and for the reasons stated therein, the second issue, while deciding the first issue, the two issues are answered full stop. While the first issue is answered in the negative, the second issue is answered in the affirmative. Full stop. Resultantly, the instant criminal petition is partly allowed.
My lord, only thing that my lord, it is further open for investigating officer.
I'm sorry. Regarding the IO of the case, Sapporo Police Station case number, not to act further on the impugned notice dated 6/8/2025 would not preclude him to call for the appearance of the petitioner under section 179 CRPC through the BNSS, through the valid mode of service.
My lord, I think, my lord, that would not require, because, my lord, they may call anytime, lordship, because
Then
even,
I'll direct more.
my lord, besides this.
Because people would misunderstand.
My lord, besides this, my lord, 179(2) lordship provides for lordship reasonable expenses, lordship, because I would require to attend in Chapor, lordship, which is more than 250 kilometers.
That issue is, my lord, is not dealing with now.
Mr. Borobuia, when
Okay.
I will not comment further.
Obliged.
Obliged. Hello,
You are
yes, sir.
suspected to be
Yes.
involved in a financial scam, having large consequences, serious consequences.
Yes, sir.
Only because of Bihan Kumar, you have got out. That does not mean that you cannot be included within the purview of investigation.
No, my lord. Sir, lordship, there are no proof at all, lord. Because I am just tax consultant and even the.
Ex-consultant. Okay, okay, it is up to you.
Yes, lordship.
We have decided the two issue. That's
Hello.
all.
Hello, my submission only, I have relied on this judgment that can be added.
Short put ঠিক আছে লিখে দিব short put
Obligement.
Item 14.
We can start only today, may not finish.
All of the issue is very simple, my lord.
Simple.
Instance.
Yes.
My lord, before
What is the simplicity?
406 or 403, whether state fed was not dissolved or dissolved at that point in time, my lord,
IPC.
my lord, before my senior friend starts, respondent number 1 and respondent number 2, my lord, they have expired.
Then the trial court will decide.
Yes, yes.
No, IPC. Why he is not under section 408? Maybe the revisional court have missed it. May not be 409. What do you think, Mr. Sharma?
My lord,
Would they come within the purview of section 408?
my lord, if I look at the wording of 408 and 406 and 403, my lord, criminal breach of trust with imprisonment for a term which may exceed 3 years or both. In fact, 409 that the lordship had said 408 by being a clerk or servant or employed as a clerk or servant or being in any manner entrusted in such capacity.
Servant is different.
No, my lord. I mean, it'll
Huh?
be the instrumentality of the state fed, my lord. That I'll not have an objection.
No,
to.
it could be instrumentality, but they are not public service.
Yes.
They are not public service.
Yes. Is
That
part.
406 is simpliciter. Criminal breach of trust,
Yes.
right? That can be anybody. Anybody
Yes, my
means A, B, or C.
Yes.
This is for 3 years.
Yes, my lord.
But you are a state fed employee.
Yes, my lord.
So it could be 408 also.
Yes, 408, your lordship has found, I did not.
That is why I suggested, but
Yes.
these are things, this can be gone into by the trial court afresh.
Yes, yes, because the order is like this actually. The impute
So
order.
this
Your
can be
lordship that they pointed me. That your order is like that.
the
Order did not change.
issue can be gone into afresh by the trial court.
Yes, my
Yes.
And if out of 3, 2 have expired, if the third is also, then nothing remains.
Third is
But-
alive, my lord. Prakhata Kumar Dotto is alive. That we have instructions on that, my lord. আপোনাৰ 2022 আছে 2022 1 মাৰ্চ 2022 পৱন ৰাজখোৱাৰ
ইয়াতে পাৰ্টিবোৰ পেনেৰে লিখা আছে না 1 2 3 কষ্ট টাইটেলত Okay. We'll narrate the facts if possible today. We are narrating the facts. Otherwise, we'll continue tomorrow.
But
The present criminal revision petition under section 397, read with section 401 of the Code of Criminal Procedure is preferred against a judgment. Here. Mr. Surya, why it will not attract the bar under subsection 3 of section 397?
My lord, not actually, we challenge that, that is.
Who
section-
challenged?
We challenge that the section, the exercising this power.
For
actually.
the accused it.
Yes, yes.
Okay,
The
okay,
order, section cannot.
okay, okay.
Charge cannot be changed. There is
Against a judgment
interlocutory.
dated 7/8/2012, passed by the Court of Learned Sessions Judge at Dibrugarh, Revisional Court, the Revisional Court for short, in criminal revision number 18 within bracket 2 of 2012. Full stop. By the judgment dated 7/8/2012, the revisional court had remanded the matter back to the learned trial court for framing of a charge of criminal breach of trust under the appropriate provisions provided in the Indian Penal Code. Full stop. Para. Before the revisional court, comma, who is Mukul Goswami? Okay, okay. Informant.
My lord.
Huh?
Government recruiter.
I don't know.
We cannot.
We cannot.
The respondent number 1 hearing preferred the revision petition against an order dated 23/4/2012, passed by the Court of Learned Chief Judicial Magistrate, Dibrugarh, within bracket the trial court. Record আছে In ZR case number 1781 of 2008, posted by the order dated 23/4/2012, the trial court framed a charge for the offense under section 409 Indian Penal Code against the revision petitioner. Full stop. Para. The facts leading to the passing of the order dated 23/4/2012 can be narrated, briefly, at first. Full stop. Para. A first information report was lodged by one Sri B.K. Nath in the capacity of liquidator, state fit, before the officer in charge, Dibrugarh Police Station, on 20/09/2008. Alleging misappropriation of funds from the Dibrugarh branch of the state fit. Dibrugarh branch of the Assam State Cooperative Marketing Roman and Consumers Federation Limited, within bracket, thereafter referred to as quote unquote the state fit, for short. In the affair, the informant, das liquidator, had alleged entirely that the state pit suffered substantial loss due to mismanagement and embezzlement of its fund. Full stop. The informant liquidator had alleged that during the period under reference, so for the period under reference, he got the entire accounts of the Dibrugarh branch of the state pit audited through senior auditors of the Government of Assam Corporation Department. Full stop. It was revealed from the audit results that the 3 employees of the state fed then working at its Dibrugarh branch, namely, Sri Ram Bora, branch manager, state fed. 2, Sri Pawan Rajkor, sub accountant, Ram Bora, respond number 1. And Pawan Rajkor, sub accountant, within bracket respondent number 2, and Sri Prashanta Kumar Datta, sub accountant, within bracket respondent number 3, had misappropriated amounts of rupees 1,52,819.54, comma, rupees 13,01,587.38 and rupees 54 lakh at Kodi 54 lakh 85,706.60. Oh no, total likhile hol 79 lakh 84,894.63 respectively. Full stop. The informant further mentioned that when the accused persons were asked to refund the allegedly misappropriate amount, the amounts misappropriated by them by his letters, comma, dated 12/3/2008, comma, the same did not evoke any response from the accused number 1 and the accused number 3. The accused number 2 tried to evade the liability by providing irrelevant explanations in his letter dated 29/4/2008, made in written in response. Full stop. Para. On the basis of the said affair, comma, the same has been registered as Dibrugarh Police Station case number 458/2008 on 25/9/2008. So, corresponding ZR case number 1781/2008. Full stop. The investigating of the officer of the case, after completing his investigation, submitted a charge sheet under section 173(2) CRPC by charge sheet number 271/2010 on 26/9/2010, finding a prima facie case against the 3 accused persons named in the affair, for the offenses under section 409 IPC, read with section 34 IPC. Full stop. Para. On submission of the SARSIT, comma, the learned trial court took cognizance and issued process for appearance of the accused persons, full stop, on 23/4/2012, comma, the trial court heard the learned counsel for the parties on the point of charge and upon perusal of the materials on record, and after hearing the parties, comma, the trial court proceeded to frame a charge under section 409 IPC against all the accused person. Full stop. When the charge was read over and explained to the accused person, comma, they pleaded not guilty and came to be tried. Full stop. Para. Aggrieved by and dissatisfied with the charge so framed, comma, one of the three accused, charge seated accused person, comma, namely, comma, Sri Ram Bora, approached the revisional court by filing the criminal revision petition from a criminal revision number 18 in bracket of 2012. Full stop. The revisional court by an order dated 16/5/2012, while calling for the case records of GR case number so and so, comma, stayed the further proceedings. Full stop. Finally, subsequently on 7/8/2012, comma, the revisional court by the impugn order disposed of the criminal revision petition. Full stop. Remanding the matter back to the trial court for framing of charge of criminal breach of trust under the appropriate provision provided in the penal code. Full stop. The revisional court had observed that the trial court shall consider the materials on record and thereafter frame a charge under the appropriate provisions of law. Full stop. Para. I have heard Mr. A. Chaudhary, learned counsel for the petitioner, and Mr. M. Sharma, learned counsel for all the respondents.
I have 3 respondents, 1, 2, and 3.
For the
No.
3 respondents.
Public prosecutor, 3.
Public prosecutor is not a party.
Not a party, my lord. In fact, respond number 4 was made a pro forma opposite party, my lord.
Okay.
Subsequently, in
Anybody
2000.
there?
Is
Okay, we'll put the name of Mr. Kosik, R.R. Kosik. For respond number 1 and 3, and Mr. R.R. Kosik, learned petition public prosecutor for the respond number 4. Closed. At the, no, Mr. Chaudhary Learned Counsel for the appearing for a petitioner has submitted that the petitioner herein has preferred the revision petition in the capacity of the liquidator, state fit, as he was the informant in the case. Full stop. Mr. Chaudhary has submitted that a major percentage of the state fed was owned by the government of Assam, and the functioning of state fed was directly as well as indirectly controlled by the government of Assam. Full stop. Therefore, the statement is an instrumentality of the state. Full stop. As the accused persons named in the affair, were employees of the state fed. Therefore, the findings recorded by the revisional court that the accused persons are not public servants under section 21 of the IPC is erroneous. Full stop. Therefore, the order judgment dated 7/8/2012 is required to be interfered with. Full stop. He has submitted that both the trial court as the revisional court are of the view that the ingredients of the offense of criminal breach of trust are present, and therefore the accused persons being public servants, the charge framed by the trial court under section 409 IPC was proper. Full stop. Therefore, the trial, a direction is called for. No, therefore, comma, the judgment of the revisional court is required to be interfered with to that extent. First, Mr. Sharma, learned counsel appearing for the respondents, has submitted at the inception that as per instructions received by him, comma, the respondent number 1 and the respondent number
2, my lord.
2 have expired
Yes.
during the pendency of the present criminal revision petition.
Yes, my lord.
First of,
I have one death certificate of response.
that will be placed before.
Yes, yes.
He has submitted about, what about 3?
3 is alive, my lord.
Okay. Therefore, comma, if the trial is to proceed, comma, the same can only proceed against the respondent number 3 as the offense, as the case could abate against the respondent number 1 and the respondent number 3. Full stop. On merits, Mr. Sharma has submitted that the employees under the state faith cannot be treated as public servants. Full stop. He has submitted that. See. As it is evident from the FIR itself, comma, the state faith was an entity under the provisions of the Assam Cooperative Societies Act.
Yes.
First of, since the state faith was a registered cooperative society, comma, the employees of the state faith did not fall within the ambit and scope of section 21
IPC.
of the penal code.
There's one more small addition, cosmetic but might not be relevant. The FIR states that the misappropriation came light during the audit for the period of 15/6/2006 to 31/3/2007. The state fed had already been liquidated prior to that, my lord. So that was also one of the other submission, that it was no longer in existence when
Under liquidation, that
yes, my lord.
at the prior-
No longer employees.
Yeah, that was just
he has further submitted that at the time of lodging of the FIR, comma, the state faith no longer as a cooperative society,
yes.
Was not in existence as a liquidator was appointed in the meantime. Stop. I have considered the submissions of the learned counsel for the parties are also produced the materials. Available in the case record of GR, case number 1781 of 2018 in original. Post. So we'll proceed on a later date.
But
When do you want? Friday, Friday, Friday. This 3 p.m.
Item 33, my lord.
33.
Yes, next week, any date, my lord.
Why? What has happened to Khabiruddin Ahmed?
Compulsory retirement, my lord. The government placed the matter before the chief minister for transfer, my lord. But written as compulsory retirement, my lord.
No, we'll not fix any date. We are grappling with 2012-13 matters, 2023 matter. Likhok. A. Chaudhary, M. Sharma lays the case on Friday. The case will be taken up at 3 p.m. Right.
And next week, any date, my lord?
No, date is not going to be fixed. Okay, we'll say that on the prayer of Mr. A.M. Ahmed, learned counsel for the petitioner, and lays the case in the next week.
Next week. God bless.